Good morning, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, February 4th, 2026. We're going to begin with the Chairman's bill, Senate Bill 323, and then here's the order for the rest of the morning and afternoon. Senator Henson, Senate Bill 268, Senator Reedy, Senate Bill 106, Senator Watson, Senate Bill 275, Senator Carrozza, Senate Bill 285, Senator Carrozza again for 367, Senator Jennings, SB 310, Senator Washington, SB 349, Senator Kagan, 354, my bill, Senate Bill 366, Senator Love, Senate Bill 296, and then the final bill today, Senator Charles at Senate Bill 352. Mr. Chairman, you're welcome to bring up your first panel as you see fit, and we'll start whenever you're ready.
Anthony Brown, Attorney General Brown, and the Secretary of the Department of Juvenile Services, Betsy Townsend. Oh, is she here? Betsy? Hey, there you are. All right. Thank you. I'm sorry. Can you guys hear me? Is that better? All right. Hey, thank you very much. Thank you very much, Mr. Vice Chair, members of the committee. Senator Smith here to enter into the record Senate Bill 323. Before I get into the sum and substance of the bill, I wanted to provide you with a little bit of background and context because I think the history here is rich and tragic, but also very interesting. And so if I could direct you to the screen, I'll give you some I'll start to explain what you're looking at. Obviously, Maryland has a long and complicated history with juvenile justice. And in 1830, our predecessors in the Maryland General Assembly had the wisdom to understand that children did not belong in the adult system and in adult prisons. And so they put forth legislation that created the House of Refuge for white children. At the time, it was actually perceived to be a pretty progressive movement and move because we were one of the only southern states that created a separate system and a separate facilities for children, separating them out from adult prisons. It wasn't until the House of Refuge opened, but because of financial considerations and concerns, it actually opened up in 1855. Consequently, black kids were still being sent to state penitentiaries and state facilities with adults for another 40 years. It wasn't until the General Assembly, 40 years later, passed legislation called an Act to incorporate a House of Reformation and Instruction for colored children. And that basically created a separate facility for black youth, and what you're looking at is that House of Reformation and Refuge, and I'll point to even the language. One is refuge for white children, and one is called Reformation and Instruction for colored children. Even the language that we're using to talk about black and white children in our criminal justice system is loaded. And what you're looking at is a they're calling it a class or school, but these are children. And I'll click to the next slide. But some of them are as young as 7 and 5, and it's all the way up to teen. So you can kind of work your way up from the bottom and go up and see that the teenagers are standing in the back. This next photo is the officers that were responsible for administering and running the House of Reformation. The House of Reformation, when it opened up, was actually was led by a Civil War general. Just to give you kind of the context and the flavor of the timing that we're talking about. And if you look at that, I mean, I think the pictures are just worth 1,000 words here. So with that backdrop, that these two systems operated separately. And another interesting tidbit of history was when there was a movement to desegregate these facilities. And they remained segregated until 1961. Or 1960, rather. It was a landmark case, State Board of Public Welfare versus Myers. And this started on February 26, 1960. Robert Myers, who was a 13-year-old black boy, sued the State Board of Public Welfare, alleging that the separate was not equal. And the attorneys that argued this case, one was Juanita Jackson Mitchell, who was the first black woman to be barred in Maryland, are allowed to practice in Maryland, and she teamed up with Thurgood Marshall and with Jack Greenberg to win this case to desegregate these two facilities, these two parallel tracks. Even more, I mean, I love this story because the portrait that hangs outside is of Thurgood Marshall after he argued the Donald Gaines Murray case, which was the building block for Brown. And so this is the history and the interconnection is just, I think, chilling and very appropriate to kind of bring up in this context of this bill. So that's the kind of the long backdrop in the history of where we are today. And as I've said before, there's a direct nexus and a through line from this history to the current practices that we're engaged in. Now, currently, under Maryland law, there are 33 offenses that there are 33 enumerated offenses that are automatically charged and send children as low as 14 or as young as 14 automatically to the adult system. And Maryland charges more children as adults per capita than any other state except for Alabama. 9 out of 10 of those children are children of color. 8 of 10 of those children are black children. And currently, and I know we just got a new fiscal note, I'll say around approximately 80% of the cases that are automatically charged in the adult court are not being sentenced in the adult judicial system. Rather, they're being dismissed or transferred back into the juvenile system. So you're wasting a lot of time and a lot of money automatically charging youths as adults under this system. It also clogs up the adult system. And you also, when the youth is incarcerated in the adult system or an adult facility, you're not going to have access to the educational programs or to the supportive programs that will help the children and the youth get on the right path and not recidivate. So you're wasting a lot of money, a lot of time, and you're getting worse public safety outcomes and worse outcomes for the children. And then I'd like to point the committee's attention to, and this is going to be entered into the bill file, but the Commission on Juvenile Justice Reform and Emerging Best Practices that this committee helped create 3 years ago, which is a collection of experts, members of this body, members of the House, that sit and meet and constantly review and evaluate the juvenile justice system and then offer ways to correct, ways to improve upon the juvenile justice system. They give that report to the General Assembly and to the governor. They did a report and an evaluation of how we're doing things here in Maryland, and they found one of the front line or top line findings of this latest report was that there's something called the Juvenile Justice and Delinquency Prevention Act, the JJDPA, that requires essentially sight and sound separation when a youth is in an adult facility. And in Maryland, they found that we were such an outlier for infractions of that law. It's a federal law. We had 1,600 violations. We are such an outlier amongst the states that they actually don't even incorporate Maryland data, those data, into the national report because we just skew the results so much. That's what we're doing here in Maryland. We're spending tens of millions of dollars, we're wasting lots of time, and we're getting worse public safety outcomes and worse outcomes for our children. So the bill before you essentially takes, of the 33, it takes 11 of those offenses and says, hey, we're not going to automatically charge those offenses and land them someone into the adult system automatically. Instead, you're going to have a judge review and evaluate the facts of the case on an individual basis and make a determination as to the right trajectory for that case. That's simply what the bill does. There's one change from last year, and that is that a child who was previously convicted of a felony and is charged with an act that would be a felony if charged as an adult, is no longer eligible for this pathway, for this path. So once an adult, always an adult for a felony if they're convicted from a subsequent felony. That's the one change that's in this bill that wasn't in last year's bill. With that, I'll ask the committee for a favorable committee report and just reiterate that when you think about two parallel paths of evaluation here, I think of one is the racial justice piece, and then I think of one, the technocrat inside of you, which is the efficiency, the judicial efficiency, the cost savings, and the better public safety outcomes. If one doesn't move you to advance this bill or to vote in favor of this bill, perhaps the other will. I think both of these together make a pretty strong case. And so with that, I'll ask Mr. Vice Chair, I'll ask the committee for a favorable committee report. I'll have the panel come up, and then I'll stand by for questions.
Thank you, Mr. Chairman. Secretary Tolentino, you are next. And while you're coming up, Madam Secretary, just for the record, because I know there's a lot of folks watching at home, there are folks in the audience and at home who would love to have testified on behalf of this bill, and folks in the audience at home who might want to to have testified in opposition to this bill. Because this is a reintroduction, we allow 2 proponents and 2 opponents in addition to the sponsor of the bill. So if anyone is wondering why this is a more compact hearing, it's because it's a reintroduction. So with that, Madam Secretary, please.
Thank you, Mr. Vice Chair. Members of the committee, I'm Betsy Fox Tolentino, Acting Secretary of Maryland's Department of Juvenile Services, and here in support of Senate Bill 323. At its core, this bill is about public safety and fairness and making decisions at the right time by the right people using the right information. The right time is early, before months of delay. The right people are judges, not at the moment of arrest, and the right information includes a youth's developmental status and amenability to treatment. The research is clear. Youth prosecuted in adult court are more likely to reoffend and commit more serious offenses than comparable youth served in the juvenile justice system. Earlier access to developmentally appropriate accountability and treatment reduces recidivism, which means fewer victims and safer communities. It is also very important to be clear. Senate Bill 323 does not shift a new population into the juvenile justice system. We are already serving this population at the Department of Juvenile Services. The overwhelming majority of youth charged with the offenses addressed by this bill ultimately return to DJS custody. We supervise them safely in residential facilities and in the community. And just to illustrate this, 60% of my juvenile detention population are youth charged as adults. 70% of the population in DJS-operated treatment facilities started their cases as adults. And overall, my committed residential treatment population are comprised of 56% of kids who started their cases as adults and are placed in 27 different facilities. DJS has shown that accountability and rehabilitation go hand in hand. Youth are held accountable through structure, supervision, and court oversight, and treatment addresses behaviors. Under current law, automatic charging makes one of the most consequential decisions in a young person's life at the time of arrest, before any judicial review. This creates long delays and harm. Youth can wait around 150 days for their transfer hearing and sometimes up to 2 years. These delays leave youth in adult jails longer than appropriate and directly contribute to Maryland's continued noncompliance with the Federal Juvenile Justice and Delinquency Prevention Act. What we have today is a lengthy system that prioritizes punishment over timely accountability. Senate Bill 323 preserves adult court for the most serious offenses while ensuring earlier informed judicial review, so accountability and intervention can occur when it matters. And for these reasons, the Department of Juvenile Services asks for a favorable report on Senate Bill 323. Thank you.
Thank you, Madam Secretary. Mr. Attorney General.
Thank you, Mr. Chairman, members of the committee. It's great to be back before the Judicial Proceedings Committee in support of Senate Bill 323 with an amendment. Mr. Chairman and members of the committee, thank you. Thank you for considering this important bill today and for the opportunity to testify. I want to thank Senator Smith for your leadership, your commitment, your passion, the manner in which you clearly articulated both the historical background, the values encompassed in this bill, and what it means for the justice system here in Maryland. To members of the committee, I have submitted written testimony that provides greater detail and background on the positions that I'm presenting today. And that written testimony also includes detailed references to any of the facts and data that I present. I am Attorney General Anthony Brown, for the record. Much of my testimony may be repetitive and redundant, and why I stand here today is not as the subject matter expert, but to convey an important value, the value of rehabilitation and what is encompassed in Senate Bill 323. I was elected by the people of Maryland to be the chief legal officer of the state. An important component of that mission is to ensure that all of our systems of justice, whether it's criminal, civil, or administrative, are in fact just and fair and accessible by all Marylanders, and that's what Senate Bill 323 sets out to do. Senate Bill 323 implements a key recommendation from the Maryland Equitable Justice Collaborative, limiting the automatic adult charging of children to address systemic inequities in our juvenile justice system. As you've heard, currently Maryland allows children as young as 14 to be charged as adults for certain offenses, and 16 and 17-year-olds can be automatically charged as adults for 33 different offenses without any consideration of their individual circumstances, prior history, or amenability to treatment. The impact falls disproportionately on Black children. While Black children make up only 31% of Maryland's population, our children represent 81% of those charged as adults between 2021 and 2023, making them more than 7 times as likely to be charged as adults as their white counterparts or peers. Maryland has the 4th highest rate in the nation of people incarcerated for crimes they committed as children. 6% of our prison population in 2023, which is double the national average. And here's what's most troubling, and the Secretary spoke to this. Roughly 85% of youth automatically sent to the adult justice system either have their cases dismissed or sent back to the juvenile system, a significant system failure, and exposes children to adult court proceedings without ultimate adult prosecution. During the pendency of these charges, youth receive few, if any, rehabilitative opportunities, as adult facilities lack the programs and specialized staff necessary for youth development. Even youth whose cases are ultimately dismissed have been denied access to educational, mental health, and rehabilitative interventions. Senate Bill 323 aligns Maryland with national best practices. More than half of all states have recently narrowed eligibility for children being charged as adults, and 8 states now require all juvenile cases to start in juvenile court. That's why we support this bill. Prioritizing rehabilitation over punishment and providing children with appropriate opportunities for treatment and reform is the right approach for Maryland. That said, we do need one amendment, and I want to preface by saying this bill should be passed even without this amendment. But we do offer one amendment to ensure effective implementation and appropriate public safety considerations, and my written testimony provides additional detail. We propose adding a pattern of violent crime definition and exception. I'm not going to spend time during my testimony outlining what that means. It's in my written testimony. We will be providing that to the committee. We do think it's important. It's consistent with the bill in its efforts to limit charging. And this bill should survive and be passed even without our amendment. I'm not suggesting that I'm offering a frivolous or meritless amendment. I'm suggesting that this bill as written is that important that there should be no amendment offered by the Attorney General that would be the demise or delay of this bill passing today. So with that, Mr. Chairman, we in the Office of the Attorney General strongly support the goals of this bill and urge a favorable report by the committee. Thank you.
Thank you. I'll go in the order in which I see senators' questions. Senator Sidnor, you are first.
Thank you very much. Madam Secretary, would you mind coming? Great. I'd like to give you an opportunity to address some of the comments from the Maryland State's Attorneys Association. I believe you may have touched on them in your testimony, but just to make it the point clear, they state that your department is tasked with providing rehabilitative services to youth, and that without appropriate services, the youth who are being serviced cannot receive the treatment they need to succeed in the future. Currently, there are massive wait lists for programs through DJS and a severe lack of services to reach all of the youth currently in the system. The courts themselves are backlogged with cases, and the Office of Public Defender cannot provide counsel for all of the youth currently in the juvenile system. So they say we should wait. Would you mind responding to that?
Yes, thank you, Senator. I think the most important thing to realize is this department is serving this population right now. I serve them every day. I've been serving them for over a decade, and we've been doing it in a way where we're providing accountability and treatment so that young people can build skills and see a pathway to change their behavior over time. We have invested even more to continue to improve our system. We're not saying we got it all, but we're going to get there, and we're adding more each time. We've added $33 million to community-based programming. I've added 50 new positions to our residential facilities. But at the end of the day, I'm serving this population now, and I have been serving this population. They're making up 60% of my detention centers, 70% of my state-operated residential treatment centers, and almost 60% of our overall committed population across the state.
Thank you very much.
Senator Love, and then Senator West.
Thank you, Mr. Chair. Secretary, expounding on my colleague's question, can you talk to us a little bit about the difference in time with a child who has been charged under the adult system versus a child who has been charged in the juvenile system, and the impact that that has, or the effect that that has on DJS?
Absolutely. So when a youth is charged as an adult, they get charged, they go to the adult system, they go to booking or local law enforcement, they have a bail review in the adult court the next day. Then the adult court decides where they're going to stay pending their juvenile transfer hearing. Often, because the law currently says there's a presumption that all youth charged as adults remain in juvenile facilities, they come to one of our facilities and they wait. On average, about 150 days to get to that juvenile transfer hearing. Some wait up to 2 years. And that is in deep contrast to the juvenile system, which prioritizes responding to behaviors as quickly as we can, because the evidence tells us when we can address behaviors with treatment, with interventions, with opportunities to build skills sooner and closer to the event, we are going to get better outcomes. So in the juvenile system, we prioritize, if a young person is incarcerated, to have their adjudication or their trial within 30 days, followed by a sentencing with 15. Those days are expanded if the youth remains in the community awaiting their adjudication or trial.
A follow-up, if I may. So to the testimony by the Maryland State's Attorney's Office, and they're raising your capacity, if I'm hearing you correctly, passing this bill will make it easier because you won't be holding these kids who have been charged as adults for so long. They'll be moved quicker. Is that correct?
Absolutely. So when a youth comes to us who's charged as an adult, they wait in our juvenile detention bed a long time. They're taking up that space for a considerable amount of time, which is almost like a dam then, right? And I can't bring in more young people because I have young people who are just waiting. If we are able to serve them more efficiently, then we will be able to create more space for more youth charged as adults or more youth who are in adult facilities to be able to come in and be accommodated in juvenile detention. We think this will make a significant change in how we serve our young people and also generate even better outcomes for the kids that we are serving while they're in our facilities.
Thank you. Thank you, Mr. Chair.
Of course, Senator West and then Senator McKay.
Madam Secretary, so good to see you. We've worked together for many years, and it's great to see you as the Secretary at this point. Congratulations on your appointment. So one of the most salient elements of Maryland's juvenile justice system, it seems to me, is the fact that every single juvenile gets released upon his or her 21st birthday. No matter what you've been convicted of, and if you've been tried in the juvenile court, the longest you can stay in jail is until the day you turn 21, at which point you get out. So I think it's important to recognize that this bill does not start every single case involving a juvenile in juvenile court. If we did, then first-degree murderers who have engaged in serial murder would get out on their 21st birthday. So could you enumerate for us, under this bill, which crimes will still begin in the adult court rather than the juvenile court?
The most serious offenses are going to remain in the current scheme of auto charging. That's your first-degree murder, your first-degree rape, armed carjacking, and several others. The ones this bill excludes and would start in the juvenile court are misdemeanor handgun possession, assault in the first degree, robbery, abduction, kidnapping, and third-degree sex offense. The most serious remain. Now, even for those offenses that start in juvenile court, doesn't mean they're going to stay in juvenile court. This puts the decision in the hands of the state's attorney to say, hey, we think this young person is not amenable to treatment in the juvenile system, that they have a history we're very concerned about, and they can ask the judge to send that case back up to adult court.
And can you confirm to me that the cases which will, under this bill, start in the adult court are cases which, based on past statistics, have ended up being tried in adult court?
The most serious offenses are the most likely to stay in the adult court. And I can illustrate this a little bit with the offenses that are being excluded from the auto charging scheme in Senate Bill 323. First of all, handgun possession. 303 kids were charged with handgun possession in last calendar year, in 2025. 81% of those kids either had their case dismissed or were brought back to the juvenile court. All right? The ones that remained in the adult system, those that pled guilty, got time served or probation, were back in the community well before their 21st birthday. And we see the same sort of structure with the other offenses that are excluded from this bill and excluded from auto charging. And I can go through them all. We added some data in our testimony that will illustrate that for you.
Two last questions. Firstly, the Attorney General suggests an amendment to add to the list of cases that would start in the adult court a charge of a pattern of serious crime. Do you support that amendment?
I don't have any opinion about the amendment. I haven't really actually looked at it, but I do not oppose it by any means.
Okay.
Yeah.
And then finally, I had one other one that's escaping my mind at the moment. Oh, yes, I know what it is. Right now, so many cases that start in the juvenile system are the subject of motions to move them to the adult system. And so many cases that start in the adult system are subject to motions to move them back to the juvenile system. If this bill is passed, do you think we will reduce the number of situations in which, in effect, a juvenile is subjected to 2 times in court, one to determine the venue in which the trial is ultimately going to occur, and then secondly, the actual trial?
Absolutely. I mean, we will be serving young people in a more efficient way, consistent with how the system is operating right now, and removing those extra hearings, those extra sort of double trials, just to determine, and those incredible delays. We know if we can serve youth closer in the time to the event that occurred, we are going to continue to get better outcomes. And by removing those extra hearings, those extra assessments, all that stuff where youth are already coming back, we are going to increase the efficiency and get better outcomes.
Thank you for your interest in my questions.
Thank you.
Thank you. I have Senator McKay, then Senator James.
Thank you, Mr. Chair. Thank you, Madam Secretary, for coming. Look forward to working with you in the future here. I just want to talk about like outcomes and oversight. Is in the bill, is there any defined metrics that will determine if Senate Bill 323 is actually successful or is failing and needs some tune-up?
So DJS is required to report on a lot of things already in current law. So each year we submit reports that encompass all our outcomes. Our report book is about 1 inch to 2 inches thick. We've just also launched a public dashboard that would continually update outcome information, not just for the young people who start in the juvenile system, but for all young people that we serve. So there's continual access to outcome information. We also have external oversight and external partners, especially through the Juvenile Justice Reform Council and evidence-based practices. I think I got it a little wrong in their title, but they also have a lot of oversight with a diverse group of stakeholders that represent all the multidisciplinary agencies that are involved in this system. They also have continual oversight over how we're operating and the outcomes we're generating.
So I guess my closing question, if I may, has to do with if the department, the system fails for delivering timely services, hearings, or accountability, who bears the responsibility? Is it the legislature, or is it the youth we're trying to protect? I mean, if this doesn't get the outcome that we are trying to get, is it going to be the legislatures bearing the responsibility, or is it going to be the department, or is it the youth in the situation that they've unfortunately chosen to get themselves in?
You know, I take our positions on legislation very seriously in coming before this body and talking about why we believe an approach is in the best interest of young people and the best interest of public safety. And when I come forward with our position, we are saying, yes, we can implement this. We can operationalize this piece of legislation. And really the proof is the fact that I'm doing it now, and I'm doing it with extra barriers, less efficiency, less opportunity to intervene when it really matters. So all we're doing is reducing delays and saying, let's intervene sooner and more effectively.
Thank you. Thank you, Mr. Chair.
Thank you. Senator James is next.
Thank you. And thank you, Madam Secretary. I am delighted to see you in your position.
Thank you.
This is a couple, and actually this could be for the Attorney General. It's maybe more of a legal, or for Senator Smith. Regardless of whether you pass the bill, when police officer charges a young person with one of these 33 offenses that are called, charged as an adult, right? Does that create some kind of, what would I call it, presumption when they go to court to argue over whether that should remain a juvenile charged as an adult or return? And, you can see why I'm asking. So when we change it, is there some presumption? If there's, I don't know how the judge comes in. Does he come in neutral and we start, from the beginning, or what's the import of that?
So
Yeah.
when we have a youth charged as an adult and the youth is asking the judge to send that case back to juvenile court,
Right.
the youth bears the burden to prove that they should be back in the juvenile court. When a case starts in the juvenile court and the state's attorney elects to ask for waiver to the adult court, the state's attorney bears the burden of proving that case should be in the adult court.
And I get that, but I'm trying to figure out whether there's any presumption that attaches to the initial charging. There may not be. I do not know this area. I do not practice criminal law, but sometimes there are laws or case law, in which there's a presumption that gives the initial decision a bit of an advantage. It sounds like that's not the case here, but I'm just checking to see.
Well, in waiver, actually, the judge gets to presume that all the facts in the charging document are true. And that's a difference from when we're going from adult to juvenile. That is a presumption that exists when we're going from juvenile to adult,
Okay,
but the
repeat that
judge
again.
makes the decision.
Sorry. The presumption, the judge assumes when a juvenile is charged as an adult that all the facts that make up the charging document are true and accurate for purposes of this decision? Is that
When
what
it
you're
starts in the juvenile court and the state's attorney asks for waiver, the judge can assume that the charges in the charging document are true.
saying? Okay, but that is not the case in reverse.
Exactly.
Okay, we can talk about what that is. And then just following up on my friend from Western Maryland, because, I understand the data concerning who's in the system, who gets charged more, and how it relates to global populations in Maryland. But what I'm wondering is there data now that shows that the difference in outcomes of those juveniles charged as an adult that are later sent back, which is a large majority, right, compared to the juveniles that start from the beginning and remain in that juvenile system? And I'm asking it because obviously the implication of here is we, the state, you, the secretary, will have better outcomes with a population of juveniles that were charged with as an adult but later returned versus better outcomes because you can show that those that start in the juvenile system and don't get elevated have better outcomes? Or is there data along those lines? It shows I'm going to have better results when I can return, and when by better results, there's a lot of components to that. And you don't have to answer it now, but I'm looking for not only like services rendered, that's what I'm looking for. I'm looking for outcomes and longevity studies that show that either the recidivism percentage go down, additional criminal activity later go down, school attendance is up. There's all kinds of ways to look at this, but so to me, we make a change because we have a very concrete desired outcome, and that will improve, not only improve these children's lives, and also improve safety in the community. So these juveniles would be less likely to commit crime and so forth. So to me, those are all legitimate and all worthy, and I'd like, this bill does that, that's very commendable, and I might support it, but I'm just trying to find out what we have in terms of data to support the concept.
Yeah, so I can tell you our 12-month reconviction rate for youth who started in the adult system and came back to the juvenile system, and were placed on probation, 82.3 had no new sustained juvenile or adult convictions within 12 months. When we look at the young people who were put in residential treatment, 87.3% had no sustained juvenile or adult convictions in 12 months. And I can break this out for you in lots of different ways, and we can come connect, and I can give you a more thorough.
I want that broken out in terms of where people started. I get that your services are good. I get that. I get that you have some success. I also don't think 12 months is enough to study, because we're talking, I'm talking about longitudinally, and I think the state should have been doing this all along. Whenever we do anything, we should longitudinally study it. So we can understand whether we're doing a really good job.
And I can come back to you and give you the 6, 12, 24, and 36-month reconviction and recommitment recidivism rates. But I will also mention the CDC has studied this and found transfer to adult court is associated with a 34% increase in violent recidivism compared to juvenile. The Office of Juvenile Justice and Delinquency Prevention has had a similar finding. The National Academy of Sciences found that transfer to adult court does not reduce crime and exposes youth to conditions that increase the likelihood of reoffending. And the Department of Justice has also had a very similar finding. So this has been studied, and we have longitudinal studies from several states that also have been far ahead of Maryland in sort of righting the wrongs of the super predator era.
And if those studies, which are great, thank you, weren't in your testimony.
We'll get them to you.
Okay, great, all right. Let me see if there's anything. Very good. Oh, all right, one last question. This just shows that I don't practice in this area. When the police are arresting a young person, they don't have discretion to decide whether the youth should be charged as an adult. They have a mandatory obligation under the current law, though. If they believe X offense was committed, they charge him with that, and that, the police probably know this is true, but that is what triggers the state of Maryland to view it like that. It's not like the police officer goes, oh, I think I'll decide that a youth should be charged as an adult. In other words, I suspect the youth of doing one of these 33 offenses, and then it's triggered, right? That's how that works. There's no discretion really by the police officer other than his, training to decide what should be charged in that moment, what he can reasonably charge. Is that correct?
Yes, so 16 and above, 33 offenses, you're going to start in the adult court. And our position is that at that time of arrest, you don't have all the information. Let's put this decision-making in the hands of a judge.
So do other states, because I can see how the way we're doing it right now is simplistic, might have seemed like an easy way to do things, but you're right, the import of that decision is huge. So are we, I guess what I'm trying to say is I wonder if at this point, once that happens, what we've done is we put the burden on the young person then, or their lawyer, to say what? That I shouldn't be charged as an adult, I didn't commit those offenses. That's what I'm struggling with. The law enforcement officers charged you with arson, I don't know if that's one of them, and some other stuff, and that's triggered it. the youth comes in, and is he arguing, I didn't commit the crime, or is he arguing, even if I did commit the crime, I just shouldn't be charged as an adult for X, Y reasons?
Yes, the youth is saying that I am amenable to treatment in the juvenile system and I should be given the opportunity for rehabilitation rather than punishment in the adult system. And they're waiting to get that chance 150 days, sometimes up to 2 years.
So it's an interesting history. I don't know if every state did this, because oftentimes we copy each other, and sometimes that's thoughtlessly. But it seems to me, in a way, police, this is never attached in a way at the moment of charging on the street. To me, the law enforcement officer charges what he charges. Immediately, it goes to court, and two sides then battle it out with a judge about where this young person should go. So I'm not sure I like going either way. I don't like predetermining anything. I feel like you should charge him, whatever it is, go to court, and in the early days, decide where this young person should go. I guess, would you tell me that this bill is doing that with 11 offenses? Or is it, again, giving a little bit of a preference? I don't even like the preference or any kind of, I just think they come in even Steven at that point, and they both battle it out as to how the case should proceed. Do any states do it that neutrally?
Yes, and that's what SB 323 is attempting to do, is to say, hey, we're going to charge this young person, we're going to get them in court, the state's attorney's going to say, hey, this is a kid I'm really worried about, they're going to argue it with the public defender in the room, and the judge is going to say, this is the system that we think we need to proceed in. And we're going to do it quickly so that we know we can get the right interventions to our young people when it matters. Maryland charges more youth as adults than pretty much anywhere else in the country. We are way behind other states and how they have addressed changes in the system and righting the wrongs of the failed super predator era, where we were saying everyone's a super predator. We know that's false. We know that research was debunked, and states have righted those wrongs. This is a very well-balanced approach to do that now.
Madam Secretary, I want to make sure we get to, Senator Sidnor has a
Sorry,
question.
I was just
Oh, please, if you have
myself
another
to-
question.
I have one more question. So in, I think I've just lost my train of thought. I had one last all right, last one. So when a juvenile is not initially charged with the 33 offenses, but it's serious, then at that point, the state's attorney could come in because of attenuating circumstance, investigatory, more information has come to light, and has that opportunity, still will have an early opportunity to ask for the juvenile to be charged as an adult. Is that?
They could do so for any offense as long as the young person's 15 years old.
Okay, so it's not even limited, it's just any offense, but they have to prove it. All right, thank you.
Thank you, Senator James. Senator Sidner has a quick follow-up. I have a question, then we need to move on to the opposition.
Thank you. Thank you very much. From looking at the opposition, talking state's attorneys and even some in law enforcement, it seems you're on two different planes. But your department, the mission is rehabilitation, not punishment, correct?
That's right.
All right. And are you able to complete your mission when an inordinate amount of children are being charged as adult and placed in an adult system rather than the juvenile system?
It makes it increasingly difficult. I want to serve these young people when they're 16, not 19, when they're 17, not 20. We are delaying the opportunity to provide the right level of intervention, the right level of supports, build the skills, regulate the emotions, keep these young people in schools, and generate the outcomes we want when we have these unnecessary delays that at the end of the day, we all end up in the same place. I'm serving them regardless. Let me serve them better is what I'm asking.
So they're missing all types of time to be rehabilitated.
Absolutely.
Thank you. And the last question, because you're here, I wanted to make certain you had an opportunity. There was a letter of information that the court put forth where they listed some concern. Have you seen their letter?
Yes.
Would you mind addressing their first concern is compliance with hearing timeframes?
Look, we have lots of timeframes in juvenile court, and this is something I believe between the courts and the parties that we can work out. As it relates to their concern about kids charged as adults being in juvenile detention, I've been doing this for well over a decade in our detention facilities. 60% of the young people I have in juvenile detention started out their cases as adults. Many judges actually even remove kids from adult jails when they can, even when they're charged with first-degree murder, and place them in our facilities. We've been doing this safely for a very long time. And lastly, I think the concern was about the time it would take to do a first-degree murder trial. And that's for kids who are 14 and 15 years old, and there's about 3 or 5 of those a year. And again, I believe we can find a way to work that out so we can accommodate everyone's fairness, rights, and timeframes.
And you have a lot of media here, and this is my last question, I'm done. You have a lot of media here, and I know within Baltimore County, our law department, our police, when they go out into the communities, they love to talk about this whole catch and release problem. Would you mind just addressing that?
Absolutely. And one of the first things I did when I started this job about 6 months ago is to re-engage with law enforcement around the state, and have spent quite a bit of time in Baltimore County speaking with your law enforcement team out there. And we have made changes to several of our operations, and we are detaining young people when they're charged with a handgun possession. We're going to detain young people when they're charged with a crime of violence until they go to court the next day and the judge has a chance to review it. Moreover, when a young person's on electronic monitoring or GPS, we had a lot of concerns about kids getting rearrested while on that level of supervision and then just being put back out into the community. We are detaining those young people. We've had to activate that policy 22 times over the past 6 months, and we are bringing them to court and allowing the court to make a decision about their continued detention.
Thank you. So my question kind of dovetails on what your answer was. And people have squinted at this, and I just want to be more candid and explicit about it. I think you have ideological compatriots on this committee who want to support this legislation, but have been hesitant in previous years to support it because of the previous leadership of the department. And so can you talk very directly and very specifically about the changes you've made in the department relative to previous leadership since you became the acting secretary that would allow those of us who support this philosophically to trust that if we were to make this change, the inherent goals that we all have, which is accountability for the children, rehabilitation for them, and public safety for our community, will in fact take place?
Yeah, I'm going to focus on 3 things. One is we have a renewed focus on our day-to-day frontline operations and supporting our frontline staff. That means we're making sure we're making good decisions at the front door of the system that align with what's in the best interest of young people and public safety, and align with our statutory obligations. And we're not just saying, go do this. We have lots of oversight. We're meeting weekly on our statistics to see if things don't look like they're working right, so we can shift quickly to support our frontline operations. We have put additional positions into our residential facilities. We have found 50 positions by just finding efficiencies to support our frontline staff, to ensure that our frontline staff are equipped to serve our young people and our young people are getting what they need. We're adding additional training, support, and coaching, also additional security measures. I have a partnership with MSP and DPSCS, Maryland State Police, Department of Public Safety and Correctional Services, to support us on improving our security operations in all our facilities. And we are doing this in a transparent fashion. I've launched a public dashboard so everyone can see what our data looks like at any given time. We are coming to community. We are rebuilding relationships. None of this system works well in a vacuum. I can't do it on the Department of Juvenile Services can't do this on its own. But when we have effective relationships with law enforcement, with state's attorneys, with public defenders, with community, we can sustain real change that will get us the outcomes that all of us want to see for our kids, for our victims, and our communities. And we're doing it, and we're seeing change, and we're seeing real indicators of success.
Thank you, Madam Secretary. Seeing no, Senator McKay, please.
So thank you, Mr. Chair. Kind of going off what you had said, sir, we obviously have now an ombudsman, and they had a report. I understand that we had that. There was a judicial briefing and that kind of stuff. Are you telling me that the changes that you're proposing are going to address some of those serious concerns that the ombudsman had brought up in that report?
Absolutely, and we are addressing them now. And we identified many of those concerns really like starting almost at day one when I started in this position, and we have been addressing them continually as we go through. We meet with the Ombudsman's office, various people in our agency, at least probably once a week. We have static monthly meetings between our leadership and their leadership. I meet with them every 6 weeks. We have a constant line of communication. We've been as open and transparent as we possibly can to support their work, because it's important work. And it's beneficial to have another set of eyes on our day-to-day operations. You know, we do have improvements, and I haven't shied away from that, but I'm serving this population now in our current system, and we are only in the past 6 months have made it better.
And just one last, thank you, Mr. Chair. Just, this will be a, isn't it so? Our relationship goes back to the days of us visiting Victor Cullen. You know, I've got a gentleman who I hired who was a graduate of there, and those kind of concerns. I believe with you at the helm and going forward and making these changes, addressing that, that this department will be able to report back to this committee that we are in a good helm. You can be safe with the outcomes, and it's a brighter future for the department. Isn't that so?
Thank you so much, Senator.
Thank you.
Thank you, Senator. We'll now move to the opposition. Thank you, Mr. Chair, and thank you to both the Secretary and the Attorney General. In opposition, we have Pam Chung from the Baltimore City State's Attorney's Office, Stephen Yates from the Maryland Chiefs Association. Whomever would like to go first.
Thank you. Good morning. My name is Pam Chung, and I'm the Juvenile Division Chief for the Baltimore City State's Attorney's Office. I would like to present to the committee that there are representatives from different counties within the state of Maryland. We have Wycomico represented, Baltimore City, PG County, Washington, Cecil County, Calvert, Harford, Carroll County, Howard County, and Montgomery County present today. Senate Bill 323 comes from an idealistic belief. I am a complete supporter of rehabilitation. I have been doing this job for almost 24 years, and 18 of those years have been in the juvenile division. That is what juvenile is all about. It's about rehabilitation. Everyone that has an interest in juvenile justice would agree that a key to curbing recidivism and breaking the cycle of violence is substantive rehabilitative services. Unfortunately, as the Ombudsman report this committee reviewed just 2 weeks ago states that the Department of Juvenile Services fails to value the youth they serve, fails to value the delivery of meaningful services and support, fails to demonstrate responsibility for youth in their care, and fails to engage in interagency coordination. This is the very agency responsible for providing these substantive rehabilitative services that are crucial to the success of the juvenile system. DJS is unable to meet the needs of the youth currently under their supervision. The agency is unable to support the idealism behind this bill. If this bill were to pass, DJS would not be alone in their deficiencies. Across the state, juvenile court systems would become overwhelmed with the influx of cases. I have taken a poll of the different jurisdictions within the state of Maryland. Our transfer rates are approximately 55 to 60%. This 85% that seems to be presented out to the public, that 85% of cases are transferred back to the juvenile system, I honestly don't know where that number comes from. It would also strain the Office of the Public Defender, who already in Baltimore City is unable to provide representation in a timely manner to youth. We have a situation where the courts have now become involved. They are now issuing show causes against the Office of the Public Defender to show why they should not be held in contempt of court, because they cannot find attorneys to represent youth in cases where there are co-respondents involved and there are conflicts of interest within these cases. The courts have also on their own started to collect data of their own, and that is part of my written testimony that I did present to the committee today. They actually presented this in one of where it's taking almost
All right.
129 days.
Ma'am, I was trying to honor, you're past your time. I was trying to give you a little bit of extra time, 2 minutes. Generally, just for the policy, elected officials are not timed. But I know that the state attorney could not be here, so if you could just succinctly conclude your remarks, I'd try to give you a little bit more time, but thank you.
Prioritizes rehabilitation whenever appropriate. And we believe accountability and public safety must also be core principles. While rehabilitation is an important goal, accountability is essential. However, this bill minimizes accountability, and particularly for juveniles charged with the most serious offenses and dangerous offenses. Current law recognizes these cases warrant heightened scrutiny and discretion to ensure both public safety and meaningful accountability, which Senate Bill 323 would significantly limit. Maryland's existing juvenile justice framework already provides a balanced case-to-case process that allows courts to evaluate the severity of an offense, a use history, and community safety concerns. Current law enforcement preserves judicial discretion, allowing judges to determine when a case should remain in juvenile court or be heard initially in adult court based on the specific facts before them. The bill eliminating the statutory provisions that allow certain serious violent offenses to be charged initially in adult court, limiting the system's ability to respond appropriately in the most extreme cases. We are concerned that restricting the discretion could negatively impact public safety, particularly in cases involving serious violence, weapons, or repeated dangerous behavior. Under current law, cases charged in adult court may still be transferred back to juvenile court when appropriate, ensuring both flexibility and fairness to juveniles involved. We have constantly heard the Department of Juvenile Services lacks significant placement capabilities. Without adequate facility space and services, youth may experience delays, inappropriate placements, or diminished access to the rehabilitation resources the bill intends. We respectfully oppose Bill 323 and request the committee to take that stance as well. Thank you.
Excellent. Thank you both very much. We have a couple questions from the committee. We'll start off with Senator Love.
Thank you, Mr. Chair. Ms. Chung, you spent the majority of your testimony talking about how DJS is failing, OPD is failing, everybody else is failing. But my question to you is it your contention that charging these children as adults and housing them in adult facilities where they are held most often to comply with federal law, sight and sound, they're held in isolation, where they actually, because of the way the facilities are built, they can't be kept out of sight and sound. So these children are hearing adults, they are being threatened, they are terrified for their lives. Oftentimes, they don't even get out of their cell because they are so scared. So is it your testimony that the children and public safety are being better served this way?
Well, it's interesting that you say that about the juveniles, because with regards to sight and sound, DJS juvenile facilities are actually the ones that are in violation of federal law with regards to sight and sound. They don't actually have to follow that particular rule with regards to their detention facilities. We recently had a case where there was an 18-year-old girl being held out in Western Maryland where they had only one facility for youth. And the DJS worker actually reached out to our office asking us to request an emergency hearing because she was being so disruptive to the younger youth that were in the facility, and they couldn't move her without a court order because she was already ordered to be in a juvenile facility pending her hearing. And so when it comes to those types of cases, we've been through many hearings, and I have to say, we're on the ground. We see this every day. And when you're in hearings and you hear that there are 18-year-olds being held downstairs in the Baltimore City Juvenile Justice Center, it's kind of like an aha moment. You just sit there and say, wait a minute, why are there adults being held with youth that are much younger? These are youth that are being held for already original jurisdiction cases, but they're being held with adults. And
That's
so
not my question, Ms. Chung. That's not my question at all. Is it your contention that is better for the kids to be in adult facilities? I'm not talking about juvenile facilities. I'm talking about adult facilities where they cannot be held out of sight and sound of the adults. Is that your contention?
It is not my contention, and I don't know of any facility that is actually in violation of that. I know
You don't know of any facility in the state of Maryland that is in violation of that?
in terms of sight and sound.
Yes.
My knowledge of the sight and sound violations are from the Department of Juvenile Services, juvenile detention facilities.
Let's talk. Okay. Thank you, Mr. Chair.
Thank you. Time is limited, so, you know, all of you, all the panels have lots to say, and I'm interested. So you gave a lot of information, and I cannot find written testimony from the collective of the state's attorneys. I see individual ones. Did the association put in written testimony?
We did. I actually submitted the juvenile justice report.
Yeah, okay. But your testimony, that's not your testimony.
My testimony was specific to the Maryland State's Attorneys Association.
Right. Did the Maryland State's Attorneys Association submit written testimony?
Yes.
Okay, under that heading, because I have lots of individual, all right, so my staff simply can't find it. All right. Might have to ask you to bring it back. If there was anything in your oral testimony that was was in addition to your written testimony, or there were things you wanted to say but didn't have an opportunity, would you, I would like that. I would assume the whole committee would, but I would like to hear anything else you had to say, not now, but in writing, anything you want to follow up with, including the exchange you just had about sight and sound violations by DGS versus, you know, the adult prisons that aren't able to do sight and sound. So specifically, I'd like to have data on the transfer issue about whether there's 85 to 55. I really do wish in all hearings, all people would just hew to the actual supportable facts on all sides. And then my apologies, because I was probably absent from committee, but you referenced an ombudsman report. I think this is for DJS. I think that was, and it was.
Yes.
It came out maybe several weeks ago.
Correct.
And you mentioned, I don't know, extraordinary failures, in my opinion.
Yes.
And so I just want to make sure that that I get a copy of that. I probably can find it, right? I don't think
Yes.
I have that.
We can send you a copy.
And so here's my one specific question. It seems like we're relying heavily on the ombudsman report. I realize you also are aware of things with public defenders. It is your position that DJS, even in an idealistic world, if we were to give them this ability, or we would change the law, that what would happen is there would be a huge influx of juveniles under the law, but because DJS is currently not serving its current population well in areas pivotal to what will be needed plus for this population, that is unwise to go forward at this point because it's not going to serve the goal they want unless they're at this moment in time or in the immediate foreseeable future. Is that correct?
Correct. So the juvenile system itself, it stands on the principle that it is a rehabilitative system.
Okay.
The adult system is for punishment.
Right.
And so when it comes to rehabilitation, the three pillars of the juvenile system is for accountability, for rehabilitation, but also for public safety.
Right.
And so when a youth commits an act, obviously, you have the accountability part. There has to be consequences for your actions. And that piece, if they take ownership of their actions, then the rehabilitative part is where DJS comes into play. They're the ones who's actually tasked with supervising and providing the services to the youth. And it's been said publicly, and I know that, Acting Secretary Tolentino, she just came into office, but the point is, they are not at a point right now to be able to service these high-risk kids when, at this juncture, they're having an issue trying to service the kids that are currently, being charged as actual juveniles. She's been very open about the fact that they're just not there. They have staffing issues. She said that publicly. There's a lot of issues with their programming. I understand that they got $30 million to possibly create more services. We haven't seen them. And from what I understand from the other jurisdictions is that these services, they're very varied. Like in Baltimore City, we had a program called ROCA. When we discussed it with other state's attorney's offices, they had no idea what we were talking about. So the different services within the different jurisdictions, some have them, some don't, and I will say Baltimore City probably has the most services through the Department of Juvenile Services. But the only way to rehabilitate youth is to actually have good services in place. And when she's going through an entire restructuring of her agency, I don't think we can say at this point that her agency is ready to handle these high-risk kids. These are not just kids going out, assaulting people. We're talking about, armed robberies, things like that. And so I think when we really look at the grand scheme of the juvenile system, rehabilitation is key. But without the appropriate substantive services in place, it's not going to work. You are setting the youth up for failure.
Let me stop you there. One thing, if there's data, and I'll ask the secretary too, about the success or lack thereof of rehabilitative services currently, and maybe that was in the report. Is that addressed in that report? You have to look at that.
What were you asking?
That rehabilitation component and your position that there's data supporting that they're not doing well with the current population. That's referenced in that report you have there?
We have the report in terms of like the recidivism rates and things like that. I will say recidivism has been kind of a contention. The Department of Juvenile Services has a different definition of what recidivism means to what the state's attorney's office believes it means. We believe recidivism is you're re-arrested, you re-offend.
Right.
To the Department of Juvenile Services, and this started with the last secretary,
I'll take a look at
Giraldi.
that. I don't want to get you off. I don't want to get you off. I'll go back. I'll just say to you all, and then the secretary, if she's still here. So I would like to get some data on the rehabilitative services. Here's my last question, and I'm sorry, I think Senator West asked this question, and maybe I didn't understand the answer. Assume that we pass this law, and these juveniles commit these 11 offenses, which have historically been considered serious and/or violent, et cetera, are nonetheless now automatically over in the juvenile system, and for whatever reason, the court sticks with that, so that's where the juvenile goes. And let's say he's person is 17 and a half, and they are resistant to any rehabilitation. Putting aside whether the rehabilitative services are good or meaningful, but they're resistant, and maybe that links to the kind of crime that was committed. And assume, these are all serious crimes, those 11. At 21, as I understand it, the hallmark of the juvenile system is that if that's where you go, that's where you stay, no matter what is going on, no matter what crimes you committed in the past or currently, you are released into the public for full freedom. There's no probation or, following up. They're free, right? So not even, the post-prison, checking with your parole officer, try to help people with services and accountability. That's it. So are there any circumstances where these juveniles have any obligations to be monitored and accountable for their behavior post being released at 21? And am I right, all are released
You're
at
correct. 21 is the cutoff.
That's it.
For
Okay.
juvenile jurisdiction.
All right, thank you.
All right, Senator Seymour, then Senator West, and Senator Bolton.
Thank you. And I'm going to use every occasion that I get when the Maryland State's Attorneys Association gets in front of us and starts talking about data to remind them that they were one of the few organizations that actually fought against getting money so that they could collect real data. So when they get up there and talk about we don't know where this data is coming from, they had an opportunity to have money to make certain that they have real data. Now, with that being said, thank you. According to the 2025 data from the Department of Juvenile Services regarding youth charged as adults, 20% of cases were dismissed. 55% were transferred to juvenile court, meaning that 75% don't go to adult court. Of the cases that stayed in adult court, only 7% received prison or jail time and 10% received a PBJ. Now, given that so few cases actually result in an adult sentence, doesn't it make sense to start at least some of these cases in juvenile court, since that's where most of them are going to end up anyhow?
That's a difficult question to answer. Other than I can say, I don't think people understand how the actual transfer process works itself. The transfer process is where the youth is charged as an adult, stays in the adult, asks the court to bring their case back to juvenile. And the difference between that and starting it in juvenile and making the state's attorney's office actually file the motion to send them to adult court, because we don't believe that the juvenile system is working for them, is that in the adult system, they actually have an incentive to work with the Department of Juvenile Services. The public defender's office will usually hire an expert who is a psychiatrist, a psychologist. And at that point, the youth will sit down with these individuals and really pour into a report that is then given to the transfer judge to make their determination of whether or not the case should stay in the juvenile system or should stay in the adult system or be moved back to the juvenile system. Now, when you switch that, you make that flip and you say to the state's attorney, well, the case is now here in juvenile, you have the mechanism to send this case up to the adult system. Completely different types of information is what we would be able to receive, because the youth has no incentive whatsoever to speak to us. Why would they provide us any information that could possibly help us get their case to the adult system? So they'll just sit quietly. All we can really present is possibly a past history, if they have a history. If they don't have a history, all we can do is maybe the nature of the offense. How serious was it? But we don't have the information that the transfer judges have, whether there's true mental health issues that we need to know as prosecutors, because there are cases where we do plead them down to the juvenile system, because we will look at these reports from the psychiatrists, psychologists, from the Department of Juvenile Services that did that deep dive on the youth, because they want to come back. The ones that do want to come back to the juvenile system, they will actually work with their attorneys and with all these individuals to try to get their case back. And then we receive those reports, and when we look at it and we say, oh my gosh, maybe this is an appropriate type of case to bring back to the juvenile system. We won't be able to do that on a waiver case because we won't have that information.
That's interesting. I haven't heard that argument in all the years that I've heard this case or this type of legislation. It's when these cases come to you all, but you do get information from victims, right?
Yes, we obviously.
So I'm just trying to understand what information that you have, because.
So the victim piece is obviously for us, because there are victims and witnesses, and these are individuals that they're entitled to give victim impact statements in terms of these hearings to let the courts know how this has impacted them, and if they have an opinion as to whether or not the youth should stay in the adult system or should come back to the juvenile system. That's happened before.
But if we use let's say we use adult terms, and we're calling the juvenile, for purpose of this conversation, we'll call them the defendant. Under our Constitution, defendants don't have to talk to you at all, right?
No, but
That's correct, right?
with regards to the
Under the
transfer
Constitution,
process,
they don't have to speak to you, right?
they don't have to speak to us, no,
Okay,
not
all
at
right,
all.
all right, so they don't have to speak to you. But you should still be able to put on your case, even if they don't speak to you.
We have to.
All right. So the argument really is we don't want this burden shifted from the Department of Juvenile Services or the defense counsel trying to waive juveniles into the juvenile system. We don't want that burden to have to fight to waive them up, although we have the information that we're constitutionally kind of allowed to have.
Let me see if I understand what you're saying.
You don't want the burden to have to convince a judge why they should not stay in juvenile court.
It's not that I don't want the burden, it's more that it's about information gathering. The more information you have, the
information?
more we can decide whether or not, what kind of services the youth might need.
But is that, now help me to understand, is that your place or is that Department of Juvenile Services' place to kind of decide those services?
I'm sorry,
Whose place, whose responsibility is that, whose duty? Is it the prosecutor's office or is it the Department of Juvenile Services? Or is it a combination of the two? Who makes that determination?
the determination to do what? I'm sorry.
You said you need to be able to figure out what kind of services that they may need.
Well, it's a combination of both, obviously. When the youth engages and actually provides information about their background, their mental health, their educational issues, anything that they think would be helpful in terms of getting their case back to the juvenile system, it becomes, at that point, the Department of Juvenile Services, in their report, will write in there what services they believe that the youth could benefit from and what they have available at that point for the youth.
I'm just trying to understand the distinction. If the system is changed in a way that this law or this bill would attempt to change it, what information are you not getting that you would need to put on the case?
We wouldn't have all of the information in terms of, we already have issues trying to get educational reports on youth just for review of court orders. When a youth is on supervision to the Department of Juvenile Services, every 30 days, 60 days, 90 days, we have a review hearing. And at that point, the department tells us what types of services these youth are participating in. Are they going to school? Are they engaging in mentoring? Are they going to therapy? But all we get is they're participating. We don't get school records unless we are subpoenaing them. We get very small sound bites when it comes to these hearings. And that's why I always say to my prosecutors, you're not just a prosecutor, you are also a social worker, because you are looking out for both the best interests of the public safety of the community, but you're also making sure that the youth are receiving the appropriate services so they're not going out and recommitting crimes.
I had a couple more questions, but I think the chair wanted.
I was going to comment on this, just to clean some stuff up. I mean, one thing that you've omitted to mention is that in a waiver hearing, the charging facts, the facts alleged, are assumed to be true. So
That actually changed.
Is that not, so that's incorrect?
That is not correct today, no.
Educate me on that.
There was a time when, even in transfer hearings, where the facts were supposed to be presumed as true. The courts don't take that into consideration now.
Is that what the statute says?
They do. I'm sorry. I don't.
So it's the law, but it's not the practice? I'm serious. Like, okay, so that, I mean, I feel like that's a very critical aspect of it. I'm looking at the statute right now.
Yes.
And it's in there in black and white. So that's the law. And that's a critical factor that I think was omitted in your evaluation of not being able to get information, because that's a huge disadvantage to the youth. If the charging facts are those assumptions, are assumed to be true in that waiver hearing. That's a huge disadvantage for the youth, and I think that's something that at least should have been mentioned.
That is only one factor. There are 5 factors
No, I
when it
understand
comes
that,
to
but
a
that's a
waiver hearing.
big deal, and I just feel like that everyone should have been made aware of that, that omission is not insignificant. Sorry, Senator Senor.
Thank you very much. Listen, I just have 2 other questions for you, and then I have a question for the chiefs and sheriff. And I wanted to get clarification. Earlier, I think when speaking to my colleague down at the end, you had mentioned that a juvenile system is for rehabilitation, and you mentioned that the adult system is for punishment. Is that the Maryland State's Attorneys Association's position, that the adult system is for punishment?
That is what the 2 systems are about.
The system for punishment.
Juvenile is specifically for rehabilitation, yes.
And the adult is for punishment.
Correct.
So we're not trying to rehabilitate people once they go into the adult system?
No, but when a case starts in the adult system, there's a mechanism for that case to come back to the juvenile system for rehabilitation.
Okay.
And that's what the courts are trying to determine. And it has a lot to do with factor number 3, which is amenability to treatment. The new case, Davis v. State, came out, which really changed the landscape of how courts are making these determinations. If there is a service there from the Department of Juvenile Services, and they state that they can service the youth, the judges are going to hang their hats on that and really lean towards sending those cases back.
Now, what would MSAA have to see from DJS? Because I think you said that essentially this is what we'd like to see, but it's not reality. So I mean, what is it that you all have to see before you all would say, you know what, DJS is ready?
We would like to see adequate services and programming. We really see the same types of programming for our high-risk offenders and our low-risk offenders. They're all receiving the same type of mentoring programs. They're receiving the same types of whether it's mental health providers. They only have a certain amount of services and programming. I know that they're working on it, but they're just not there yet. And to change the system completely at this point, when the actual services aren't in place, now you're bringing in more high-risk youth to start in the juvenile system without the actual safeguards in place.
Thank you, Ms. Chung. And I'm sorry, the gentleman from the Chiefs and Sheriffs, and I'm using my word, not yours, but you testified about how this legislation would, and again, this is my word, not yours, but this is what I got from you, that it would undermine accountability. Am I catching what you were trying to deliver all right?
Thank you for the question, Senator. Accountability with juveniles, if they commit a serious enough crime that they need to be one of those 33 offenses, start in the adult system. They need to be held accountable for public safety. They're 33 of the worst offenses in the state. So,
and when I hear that, what I'm hearing is this perception that this bill is essentially a get out of jail free card, and not necessarily we're going to start you in. We're still keeping you in the system. We're just starting you at a different place in the system. And is that correct? I mean, you're still in the system, right?
yes.
It's a different system, but you're in the system.
Yeah, and it's kind of a less of a system because it's not the adult system.
Because you want the juvenile punished, or because you want the juvenile rehabilitated?
Whatever is best for public safety. And
is it not best that someone who's out committing crime is rehabilitated so they don't do it again?
Oh, I completely agree. If they can do rehabilitation and it works, then that's good. And Ms. Chung hit on it. I don't think the new Madam Secretary, DJS, has done a great job in her short tenure, but I don't believe they're there yet to what she said, to deliver these services, to make sure they don't reoffend and they're not a public safety risk.
And we heard from the secretary that the department is ready. And you have a number of people here who are willing to hold the department accountable, talking to accountability,
Yeah.
to provide the services to these youth. So when we're talking about undermining accountability, I'm trying to understand what accountability does this bill undermine? What is it that you're talking about?
That the juveniles are committing the crimes, the holding.
So they've committed a crime,
Yes.
and then they're going to go through the system, and the system is going to do what the system does.
Yes.
That's not accountability?
Well, it will be, yeah.
Okay, thank you.
Okay.
Thank you, Mr. Chair. I guess Ms. Chung, if you would stand up there again. So at this point, there are 33 different crimes that that automatically start in the adult court, correct?
Correct.
And if this bill were to pass, then fewer crimes would start in the adult court. Some of the crimes that currently start in the adult court would start in the juvenile court. Right?
Correct.
My view all along has been the crimes ought to start in the court where they're most likely to end up based on statistical evidence. So if a particular crime, let's say first-degree murder, is likely to be tried based on the stats in the adult court, that's where it should start. And if shoplifting is likely to be tried in the juvenile court based on the stats, that's where it should start. So this bill doesn't go all the way as far as some would like, which is to assign all the cases to juvenile court. This just selects a couple of the crimes, the 33 crimes that currently start in the adult court, and has them start instead in the juvenile court. Would you agree with me that the applicable statistics show that cases in which these crimes that are being reassigned are charged have in the past overwhelmingly ended up being tried in the juvenile courts?
I don't believe the statistics are accurate. I know for our statistics in Baltimore City, we only have a 55% transfer granted rate. The majority of them are handgun cases, but unfortunately with those handgun cases, a lot of them end up in the community where they're serviced by the Department of Juvenile Services. And in our juvenile justice report, there is an appendix that it was attached to it. Unfortunately, it was too large to upload, but there are many case studies that we have attached to that with regards to the recidivism. And that does go to recidivism. As I was stating, our definition of recidivism is when a youth actually re-offends. The Department of Juvenile Services does not count recidivism until a youth is actually found fact sustained. And at that point, as Acting Secretary Tolentino stated, that's for a 12-month period. So if a youth is on supervision and then they pass that 12-month period, if they re-offend after that, that's not counted in terms of the recidivism rate for the Department of Juvenile Services.
Okay. So if you can come up with statistical information which would suggest that one or more of the crimes which is being reallocated by this bill to start in the juvenile court, that one or more of those crimes that has generally speaking ended up being tried in the adult court, not the juvenile court, I would love to see those stats, because it may be that we've reallocating one or two more crimes to the juvenile court than we should.
Okay.
Or conversely, we maybe should have a couple of crimes that are currently allocated to the juvenile court that we should add to this bill to be assigned to the adult court. So if you can come up with information, statistical information that suggests that one or more of the crimes that this bill reallocates to the juvenile court ends up typically being tried in the adult court, I'd like to know that information. And let me just finish by saying, get you to confirm that the crimes that start in the juvenile court, the juveniles are held pending the trial in juvenile facilities, correct?
Some, yes, most.
Most.
In Baltimore City, we actually have a detention facility specifically for youth. It's called the Youthful Detention Center. And at that point, anyone under the age of 18 that has committed an offense that automatically charges them in the adult system, that is where they start. And at that facility, they have all of the services in place. The Eager Street Academy is there. They have mental health services. They actually have a doctor and a nurse on staff. And so that facility is fully staffed.
Okay. And then finally, I'll stop there. Thank you for your answers to questions.
Thank you, Mr. Chair. Thank you for coming today. I think you started to answer it. I just want to be clear on the record, though, that when we have doesn't the law currently, as it's written, require the juvenile to be moved to a juvenile facility in all arrests except for first-degree rape and first-degree murder?
No. So what has been happening is when the youth is charged with an automatic adult offense, they are taken into custody. And at that point, that is when their attorney will file a motion to have their physical body moved to a juvenile facility. And I know that some jurisdictions don't have that facility.
So you're saying that's not the actual process then, that they're not all moved except for those two most egregious offenses?
The majority are moved, yes.
Okay, thank you.
Thank you very much, thanks. Just wanted to, this is my last round of questions. I wrote down when you were testifying, Ms. Strong, about the, like the JDPA, the sight and sound separation, the requirement, and that most of those violations came within the Department of Juvenile Services, their facilities. I was wondering if the law requires sight and sound separation from adults and juveniles are the only people who are present in a juvenile facility, maybe a little older, like, I don't know, how is that even possible that a juvenile facility could have a violation of a law that requires sight and sound separation for adults?
Because the youth could turn 18 pending their transfer hearing,
Right,
and so they're not actually moved. They've been court-ordered to be in a juvenile facility, and so when they turn 18, they stay there.
So for just in like real life terms, like is a 16-year-old being exposed to an 18-year-old or someone who just turned 18, is detrimental to someone's, is that as detrimental to someone being 16 exposed to like a 40-year-old or a 50-year-old? Is that?
Well, I don't think, and excuse me, obviously, Senator has some statistics of her own. When we talk about sight and sound, my understanding is they're not actually being housed with the adults.
No, I get
They're
that.
housed in an area where possibly the sight and sound may be violated, but they're not actually being put in a cell with a 40-year-old.
I understand that, but just as a matter of like consequence, like I think the levels of exposure are different. But the information I have is that the thousands of violations were in the adult system, not the juvenile system. So I would, if you could give us the information, that would be, just so we can make a better decision. I mean, I would like to see that.
So with regards to that, I think my analogy would be that, you have an 18-year-old that's actually being housed with younger individuals that are actually juveniles. They're in cells together, in community areas together. And so for me, and I think for the state's attorneys, that is actually more harmful to the younger youth to be exposed to these individuals who are there for violent crimes versus a youth that's being held in an adult facility where they're not actually being housed with the 40-year-olds. They're just in an area where they're supposed to be separated by sight and sound. So they're not actually interacting with the adults.
Okay, I think some people would probably disagree with that characterization, but can we go on to, you said you guys 55%, you said 55% transfer or?
Yes.
Okay. So then how many do you all dismiss? How many cases get dismissed that you all charge?
I think last year we dismissed approximately 3 or 4 cases.
3 or 4 cases, period?
Yes.
3 or 4 cases. So, okay. And then is that's your jurisdictional percentage?
Correct.
That's for Baltimore,
Correct.
right? I think statewide it's more like closer to 20 or something like that, right?
There are other members of the state's attorney's office present from the different
It's
counties
around-
if you'd like to
I think it's a little
ask
higher
them.
than 20%. And then for the transfer or the waiver hearing, for the hearing, you said, and we talked about the facts alleged and all that stuff, the charging facts alleged, and that's already kind of alleged to be true, and that's in there, which is a huge disadvantage to the youth. But for if a youth was not cooperative with your efforts, wouldn't that go into the amenability of their rehabilitation? Isn't that the primary factor to consider these things? I mean, so I'm trying to understand. Wouldn't you argue that? I'm sure
We
you do
can argue that,
Yeah.
but the courts, with regards to how much weight they put on that, it's obviously up to the court to make that determination. But I will
Understood.
say, amenability to treatment is the number one factor that the courts are taking into consideration, because the juvenile court system is about rehabilitation, and they want to know, are there services available, and are the youth going to be participating in
I think you're
these
making my case for it. I
services?
mean, like, yeah, if that's the number one factor for the juvenile jurisdiction, if a subject is demonstrating to you through their non-cooperation that they are not amenable, that seems to me to be a pretty strong case that they should be waived up.
Well, the types of information that we'd be trying to receive from the youth, they may not want to talk to us, and the courts will take that into consideration. They will understand that it could possibly be used against them in terms of whatever they're trying to show, and that is why they would not want to cooperate with us. It's not that they're saying they're not going to cooperate with services that are put in place with them. They're going to say, I don't want to talk to the state's attorney.
I understand. Well, listen, I appreciate the state's attorneys. I appreciate you all being here. As a policy matter, I have struggled to understand why there's so much opposition to this iteration of the bill, honestly. I'm not a bleeding heart on all this stuff. I'm just trying to follow the information and make an informed decision as a policymaker. I struggle to understand the level of opposition on this bill. But thank you very much.
Thank you.
All right. I think that's it. With that, that'll conclude the hearing for Senate Bill 323. We are now going to go to Senate Bill 268, which Senator Henson, I understand, Chief of Staff, is going to go ahead and present, and then we'll move forward with the panel. We'll just go ahead and wait until just the room clears a little bit. Sorry about that. Okay, if folks could just keep their voices down as they make their way out of the committee room. All right. Thank you very much. Go ahead. Yeah. Welcome.
Good afternoon, Chairman Smith, Chairman Ballstreicher, and members of the committee. For the record, I'm Dr. Linda Hannafin Bonner. I'm representing Senator Shanika Henson, District 30 in Anne Arundel County. And would like thank you for the opportunity to present this bill, Senate Bill 268. We have a number of expert people who will also come and testify on the bill, and I will introduce them shortly. Senator Henson would like to urge a favorable request for this bill. Fundamentally, the legislation puts in place classic clinical safeguards to ensure that individuals with intellectual disabilities are not inappropriately placed in prolonged restrictive housing for no more than 15 days within a consecutive 30-day period. Over the past months, there have been close collaboration with the Maryland Department of Public Safety and Correctional Services and their medical team to ensure that both the safety of their correctional officers and the incarcerated individuals are taken into consideration. We want to point out that this bill applies only to state correctional facilities, and it authorizes a clinical professional to evaluate the newly incarcerated person during the intake process for a developmental or intellectual disability category. Based on the assessment, the clinical professional may recommend to the correctional facility that the incarcerated person should not be placed in restrictive housing for more than 15 consecutive days. The limit on restrictive housing does not apply to an incarcerated person who has committed a prohibited act. The legislation further does not expand the use of restricted housing. Rather, it establishes the statutory limit where none currently exists. Under current practices, individuals, including those with intellectual or developmental disabilities, may be held in restrictive housing for an indefinite period. More importantly, the bill creates an initial enforcement guardrail to prevent extended isolation period to those suffering with legitimate mental health issues. The bill's definition also is intentionally tailored to the most restrictive and harmful forms of isolation, that being disciplinary and administrative restrictive housing. Exclusions from medical isolation include mental health observations such as suicide, protective custody, and quarantine, which will ensure that necessary access to care and safety measures are not intended as loopholes. While there's broader forms yet to come for this particular legislation, the legislation establishes some meaningful limits with respect to future changes. In the discussion that has occurred over the past week, there are likely to be a few favorable amendments taken into consideration during our discussion process within the committees. I would like to introduce Donald Provello, who is a recent inmate who has experienced both solitary confinement and treatment experience. Terry Stakes and Christopher Dews, who are representing the Out for Justice Prison Advocacy Reform Group. Dr. Teresha Downing, who is an experienced mental health professional. Judith Leichenberger, who is an attorney for the Maryland Association of Justice. And Kimberly Watts, who's with the Public Defender's Office. This bill has received significant support, as you will see with the testimony. And the few items with opposing viewpoints we believe can be addressed later on in our committee's discussion. And so we would like to urge a favorable report on this bill. So I'd like to introduce first Mr. Provello.
Good morning, ladies and gentlemen. My name is Donald Bovello. I served over 35 years of a life and 20-year sentence in Maryland prisons, all in maximum security. During that term of incarceration, I did 2 periods in the solitary units, once disciplinary segregation, the other administrative segregation. I also, during my incarceration, worked several jobs which required me to work in the units where individuals with mental health issues, intellectual disabilities, and physical disabilities were housed. So I saw and witnessed firsthand the effect of being confined for long periods of time had on individuals. For myself, my time in disciplinary segregation was 14 days. I'm going to put it very plainly. That 14 days killed me. I spent 15 days in administrative segregation. That killed me. That's a long time to be isolated with no contact with anyone. All you hear is screaming and yelling. You smell things like urine and feces, and you're treated very poorly. Often your meals are served cold. So the experience of that type of isolation has an effect on any individual. Individuals in prison that have intellectual or developmental disabilities that are exposed to that type of treatment have a negative reaction to it. Not because they're bad people, it's a fear reaction because they don't want to be treated in that way anymore, and they'll do anything not to be treated like that, not realizing that their reaction brings that type of seclusion. So in my experience, the only effect that prolonged terms and restrictive housing has on individuals that have intellectual and developmental disabilities is a negative one, and I urge that you please give this a favorable report. Thank you.
Jerry?
Good morning. My name is Terry Speaks, and I'm here on behalf of OFJ Out for Justice, Center for Urban Families, and Life After Release, our coalition partners on this bill. I'm here to speak about my experiences spending time in the Department of Corrections as well as in the federal system. The longest I've ever stayed in restrictive housing is 6 months. When you wake up in the morning, about 5 o'clock, they cut the lights on. They don't go off until midnight. Like the gentleman said, the food is served cold. You only get to get out and get showers 3 times a week. You have no type of recreations on the weekends. And the majority of the time, the correctional officers inside the institution, they punish you for if you disagree with them. If you have an opinion, you're put in solitary confinement. I've experienced this firsthand. I experienced this when I was in ECI, Eastern Correctional Institution, and it breaks down your mental. You start to see things, you start to hear things, and a lot of times you're afraid to even ask to see a psychologist because you're stigmatized when you're inside the institution. If you go to psychology and you try to seek some type of mental health issues, I urge y'all to give this report a favorable, give this bill a favorable report because it's unfair, it's unjust, it's definitely inhumane for you to be in restrictive housing when you have mental health issues. I've been diagnosed with mental health issues, and I actually see a therapist for my time being incarcerated, and it took a toll on me, and I couldn't get that help when I was in there. And a lot of it came from when I was isolated with inside the institution. So I do ask y'all to get this bill a favorable report, Bill 268. Thank you.
Hello, everyone. I'm Dr. Tricia Downing, and I'm just here to speak about the literature review that I've done in terms of what we see, the effects of these housing units on people with intellectual disabilities as well as serious mental health disorders. Those two things can happen at the same time. And as the previous gentleman said, he sought care after just from being in those situations and being in prison in general. So one of the things that I wanted to point out is that early detection of these things is important in terms of knowing whether or not a person even has a developmental disability. These things are very easy to do in terms of when a person is incarcerated, and they can, it doesn't take very much more than what's being done. It just has to be recognized and flagged. Once these things are flagged, we can limit the amount of time to that 15 days and have an intervention to make sure that a person isn't continuously in restrictive housing, which has been shown by numerous studies. I mean, I ran out of time going through all of the studies that show that it is highly necessary for someone to receive treatment and interaction to avoid to enhance their improvement with their disorder. But you add that with restrictive housing and you take all of their care away, they get worse. So I would like to request a favorable report. Thank you.
Good afternoon, everybody. Christopher Dews representing Out for Justice in full support of Senate Bill 268, specifically to restrict the use of restrictive housing on individuals with IDDs. Out for Justice, for context, is a network of formerly incarcerated individuals working on policy reforms for the specific population of those who have experienced life behind the walls. We have dozens of members that we work with who have experienced restrictive housing and can speak to the process, as Terry has already done, and the impact on themselves, but not just themselves, their families and their colleagues. When individuals experience this and they come home, it does have trickling effects. And Out for Justice specifically has dealt with a lot of individuals trying to get them housing and trying to get them employment opportunities. He can speak to the damage that this stuff does to individuals. As such, we would love to see this policy pass into law and then expanded, not just for this population, but for others, to acknowledge the harms that this specifically does. But as for right now, we think starting with the IDD community, who are most vulnerable to this specific practice, is an incredibly good first step. That said, we simply urge a favorable report. Thank you.
Chair Smith, Vice Chair Waldstreicher, members of the committee, we thank you for your time today. I'm Kimber Watts. I'm an attorney with the Public Defender's Office. I've been practicing as an attorney representing people in criminal cases for 25 years. I'm currently the chief attorney for our Forensic Mental Health Division. I hope that you can hear me okay. I'm not here to tell you about how bad solitary confinement is. You've already heard that. I am here to talk about some of the legal ramifications. I can say OPD supports this bill because it offers some protections to our clients who have intellectual disabilities and are incarcerated. I understand some of you may have some questions about the constitutionality of the bill, so here's my read of the law. The Equal Protection Clause of the U.S. Constitution and Maryland Declaration of Rights requires that you pass laws that are rationally related to a legitimate state interest. Here, you certainly have a legitimate interest in the conduct of Maryland's Division of DOC facilities. Additionally, I think you have a legitimate state interest in protecting people with intellectual and developmental disabilities. So what I can say is currently there are no limits on the length of the use of restrictive housing, also known as solitary confinement. Imposing a 15-day limit for people with disabilities, these intellectual disabilities in particular, recognizes their unique vulnerabilities, and you certainly have a legitimate state interest in limiting the harm done to them in the facilities that we control. Therefore, there is a rational relationship to a legitimate state interest, and as always, I am happy to answer any questions that you might have. As I said, OPD urges a favorable report on this bill. Thank you.
Good morning, Chair Smith, Vice Chair Waldstreicher, and members of the committee. My name is Judith Lichtenberg, and I'm speaking today on behalf of the Maryland Alliance for Justice Reform in strong support of this bill. I'm Professor Emerita of Philosophy at Georgetown University, and I've been teaching philosophy in the University of Baltimore's Pell Grant College program at Jessup Correctional Institution for 10 years. This issue recently became personal to me. A student whom I knew well, a man with a lot of potential, spent a prolonged period, close to a year, in restrictive housing. He was released then, after a few months, was put in a holding cell for a minor violation. There, he hanged himself. This did not have to happen. This legislation is a clear, necessary, and humane reform. It ensures that individuals with developmental or intellectual disabilities are clinically assessed at intake, that professional judgment guides housing decisions, and that restrictive housing is not used in ways that cause individual predictable and lasting harm. People with cognitive and developmental disabilities are uniquely vulnerable in correctional environments. Their behavior is often misunderstood and punished rather than clinically addressed. When they're placed in restrictive housing, the effect is destabilizing, traumatic, and often permanent. By requiring clinical assessments, authorizing professional recommendations, and limiting prolonged isolation, this legislation creates safer institutions for everyone, reducing crises, improving stability, and promoting institutional order. Our one concern is that to meet the bill's requirements, a sufficient number of mental health professionals must be hired in correctional facilities. But the mental health benefits and consequent reduction in restrictive housing could help offset that expense. We Major, urge a favorable report on this bill. Thank you.
we have anyone else signed up to testify virtually? Are they in the room? Okay. Is Perpetua Abangala here? No? Oh, she's coming? Oh, there she is. Okay, great. And, yeah, Angelina Scarton? Is Angelina here? And then we'll go, after your testimony, we'll go to the virtual folks who were testified favorable with amendments.
Would you like us to step back?
No, just in case there are questions, we'll finish up with this panel, and then we'll, thank you very much, though. Welcome.
Thank you so much. Good afternoon, the chairman. Good afternoon, vice chairman and the board of members of the commission. Thank you so much for the privilege to testify. My name is Perpetua Abongnala. I'm a Maryland resident in Montgomery County. I strongly support the restrictive housing bill for the individuals with developmental or intellectual disabilities, DDID, because many lives will be saved. My son, Funiba Abongnala, a 27-year-old African-American, was incarcerated at the age of 20 and almost lost his life in RH, restricted housing. Funiba has serious mental illnesses and a seizure disorder from December 17, 2024 to November 28, 2025, Funiba experienced severe abuse, neglect, and assault while incarcerated. He witnessed correctional officers assault his cellmate until he became unconscious. Funiba was also assaulted by same correctional officers and locked up in restricted housing for a total of 10 months out of 11.5 months that he spent in that facility. Although Funiba's cellmate record indicated that Funiba complied with the correctional officer's instructions, while his cellmate did not, Funiba's record also stated that Funiba violated institutional policies. He was, among many things, denied food, medication, medicals, showers, Bible, adequate out-of-cell time, and fan during the entire summer of last month. I filed grievances with the Department of Public Safety, Correction, and other agencies in Maryland State. Investigations were initiated, but with no resolution. So I got connected to a mother's cry, who referred me to the Ombudsman office, and the Ombudsman office stepped in and pulled Funiba out of that institution. Funiba is placed in a new place now where he is recovering. Without the Ombudsman office, Funiba would have lost his life like many others. Funiba has lived in 7 Maryland state prisons and has witnessed several corpses of inmates being taken from restricted housings. And some of them defecate, like somebody said here this morning, and others urinate in containers while ingesting and throwing them at the officers, and resulting to more consequences. Funiba has made some mistakes and has improved. He takes accountability for his actions, and he strongly also desires improvement, for the restricted housing policies, not just for himself, for his colleagues, for his fellow inmates too. So please remember my son's story as you make these critical decisions about restricted housing. Thank you so much.
Turn to questions from the committee. Seeing none, then we're going to switch over to our panelists who are joining us virtually. We're going to start with Jake Dolinsky. Is it Jake? Jake, all right. Jake, go ahead, you're up. And then while we're waiting, Ms. Warnken, you're signed up with favorable with amendments. Come on up.
Are you guys able to hear me okay?
Yes, Jake, we are.
All right, I'm going to ask that you bear with me. I would have been there in person, but I am very, very sick. So just please bear with me here.
We appreciate that. Thank you.
Of course. Yeah, my name is Jake Dolinsky. I am actually the vice president of Autism on the Go. I'm someone living with autism and a mitochondrial disease. I'm here in support of Bill 268 with amendments. At its core, this bill is going to save lives. The question isn't how many. If it saves one, that's enough. Let's just start there. No bill's ever going to solve everything. I've had the honor of working in Capitol Hill and in Congress, and so I know if we're waiting for a perfect bill, it's never going to come. What we can acknowledge is that this is a massive step in the right direction. We can commit to keep working on it, and at the same time, acknowledge that we still have work to do. That's just called being human. What we can't do is pass it and be done. I think it was Senator, I want to say, let me get this. Senator McKay actually said earlier in this hearing on the first bill that we need to see like metrics, right? And so my amendment, just so we're clear, is literally I want to report in 6 months on what this is doing. I think we owe it to people like me to Sorry, I'm shaking because I'm sick, so I apologize. This is incredibly personal to me. We owe it to people like me to not just say that we're hearing us, but to actually hear us. And there is a certain level of emotion that I can't express as someone who's lived in Montgomery County, that I've had friends die over this, and I'm currently battling COVID and the flu, and I felt it was important enough for me to show up today to let you know that, you know, the UN's, you guys know this, the UN standard is 15 days. That's the accepted UN standard under the Mandela effect, under the Mandela rules. The AG said earlier, we're talking about equity and statewide alignment. This aligns us with other states. I can quote New York, I can quote Colorado, but at the end of the day, the constitutional argument to me isn't valid. It's state prisons only, which means our state controls what happens there. So constitutionally, we're safe and we're sound. I really just want to stress that this is a step in the right direction. So if nothing else, for people like me, for the people you've heard today, it's not perfect. It's never going to be perfect, but something is better than nothing. And I just want to thank you guys for the time and for allowing me to share my thoughts on this. And I look forward to any questions you guys may have and continuing to push this through. Thank you.
Excellent. Thank you very much, Mr. Dudensky, and I hope you feel better soon. So get well soon, and thank you for joining us. Ms. Morgan, yes.
Good afternoon, members of the committee. Heather Warnken from the University of Baltimore School of Law, Center for Criminal Justice Reform. I just want to start by emphasizing our strong support for the goals of this bill. As you've heard, solitary confinement amounts to torture for any human being, but it's particularly damaging for persons with mental disabilities, including intellectual disability, and can lead to grievous harm, including death. It's for this reason that we are fully supportive of the ongoing dialogue surrounding the amendments needed to strengthen the ability of this legislation to accomplish its goals, elevating it from an authorization for greater protections for this vulnerable population to an actual mandate. Because of the serious risk of harm, it's crucial that individuals are actually screened and identified. Yet, given the nature of confinement settings, and in particular in this moment of widespread crisis surrounding inadequate staffing and resources inside, the reality is these disabilities often go unidentified. This not only subjects vulnerable members of the incarcerated population to grievous risk, it also deprives correctional staff of the critical information they need to effectively and humanely do their jobs. Without a mandate and appropriate resources, it can be very difficult to determine even whether a person should be screened. Thus, the may language in this bill, without assurances that it will happen, will undoubtedly lead to more of the status quo, persons with disabilities being overlooked. People with developmental disabilities often are aware of the stigma surrounding their disability and can go to great lengths to mask it. This, in the literature, is often called a cloak of competence. This is particularly relevant in the prison and jail setting where having a disability can make a person uniquely vulnerable to abuse. Members of this population are already more likely to be disciplined when disabilities are not identified. For example, if they have difficulty following instructions without appropriate accommodation. Without ensuring screening occurs, these problems will persist. Again, we support a favorable with amendments position on this bill.
Excellent. Thank you very much. Seeing no questions from the committee, thank you. So that'll conclude the testimony for the favorable with amendments. We'll now go to the opposition panel. We have Lucien Parsley. Ms. Parsley, welcome back.
Good afternoon, Chairman Smith, members of the committee. Lucienne Parsley, Disability Rights Maryland. We're the state's protection and advocacy center for people with disabilities. We really appreciate the attempt to limit the use of restrictive housing for people with IDD. It seems like there's a lot of agreement that amendments would be helpful and needed. But we really, I feel like the emperor has no clothes. 15 days out of every 30 days is an enormous amount of time for someone to be in restrictive housing. States and jurisdictions around the country are moving to ban or significantly limit the use of SEG. Half your time in restrictive housing is not that. The United Nations, the Mandela rules that were mentioned actually say that restrictive housing or solitary confinement should not be used at all among groups, the vulnerable groups, and that more than 15 days constitutes torture. So we feel it would be a step backwards for this committee and the General Assembly to give the imprimatur of legitimacy and constitutionality to keeping people with IDD in restrictive housing for 15 days out of every 30 days. And potentially more than that, given that the definition of restrictive housing is changing in the bill. It's narrowing it so that many things that would ordinarily be considered restrictive housing would be out of that, such as protective custody, the inpatient mental health unit, special observation housing would no longer be considered restrictive housing. The bill also chooses one group of people with disabilities, people with IDD, to have this purported benefit, while choosing one group of people without a rational basis, as my colleague mentioned, meets with the rational basis review of the Equal Protection Clause of the Constitution, choosing one group over other groups of people with disabilities does not. And it also violates the Americans with Disabilities Act and Section 504 of the Rehab Act. We have proposed amendments that we think would be very helpful to resolving the issues.
Excellent. Thank you very much. Questions from the committee? Senator Sidnor.
Thank you. It seems most of the proponents, they've been kind of addressing this argument around constitutionality. And I read your testimony, and I'm still trying to wrap my head around the argument. Your testimony didn't point to any specific case that you think or that your organization believes would make it unconstitutional. Could you help me to understand? Is there a case law about this, or this? Because it says it may be, so which tells me that this is an assumption that you all are making, not necessarily something based on case law.
Senator Sidnor, I don't know that there's been this specific fact pattern, but there definitely are fact patterns where one group of people with disabilities are chosen to receive a benefit over other people with disabilities. For example, people with traumatic brain injuries, people with serious mental illness, people with dementia who would not benefit from this. And there is no rational basis for doing that. That violates, I've seen cases that violate, that is shown to violate, or courts have said that violates the Americans with Disabilities Act and Section 504 of the Rehab Act. I can get you additional information on that if you like.
So it's because of the bill referencing, I guess, definitions of developmental disability or intellectual disability. You're saying that there are folk who are excluded from these definitions, and then
of course, yes,
they would have a complaint?
Yeah. So if you are a person with a traumatic brain injury and you're being kept in SEG and not, or in restrictive housing and not able to take advantage of this restriction, there's a good argument that the state is discriminating against you based on your disability, based on your diagnosis. If DPS is saying to you, I wish we could say you could only stay in SEG for 15 days out of every 30, but because you have a traumatic brain injury and you don't have an intellectual or developmental disability, we can't make that benefit available to you.
I'm just assuming that the definitions, and this is your area of practice, not mine, that these definitions would be as encompassing as, or all encompassing, but it just makes me wonder if these are the definitions. Are there constitutional problems elsewhere that rely on these definitions?
For example, things like states that make certain Medicaid benefits available to people with one type of disability over someone else that does not have a disability. There have been challenges to that, for example.
And the gentleman who testified just before you, he said that there are other states that do this. Have those states, are you aware of there being constitutional challenges in those states, or what made those states that had these types of restrictions in place constitutional?
I don't think that gentleman was specifically referring to limits on the use of restrictive housing for one group of people. I think they were talking overall, states are adopting limits on the use of restrictive housing, and some states have, I mean, it varies, but what the trend is across the country to limit the use of restrictive housing. Colorado has banned, New York City, yeah, so.
Not necessarily just for people with disability, just across the board.
Across the board, right.
Thank you.
You're welcome.
Any other further questions from the committee? All right.
Thank you.
Seeing none, thank you very much. With that, that'll conclude the hearing for Senate Bill 268. We'll now move on to Senate Bill 106 with Senator Reedy. Welcome back to JPR, Senator Reedy.
Thank you, Mr. Chairman. It's wonderful to be here with you all. And I've got a bill that I think is going to be a great consensus bill. You've had a lot of discussion for the last hour and 45 minutes about some important issues in criminal justice. My bill is a bill that will allow the state to declare victory on something we've won and give drivers and taxpayers a little bit of a break. Senate Bill 106 repeals the Maryland Vehicle Emissions Inspection Program, VEIP. It's an outdated, costly program that no longer is serving the purpose that it was created for. Between emissions testing fees, which were just increased this last year in the BRFA, additional MVA costs, and recent registration increases, Marylanders are facing growing financial barriers to just keep a vehicle on the road. We all hear it from our constituents, I believe. I believe I can say, I'm assuming you have as well, that we hear from constituents all the time about car registration taxes, about other costs to keeping a vehicle on the road. The vehicle emissions inspection program started in the late 70s, and the idea was we had some very bad air quality in the Baltimore-Washington region, a lot of smog, a lot of issues. And so this program was started, and it was for counties that were within the corridor, basically, of that area to pay to make sure that they were checking that their emissions did not exceed standards so that we could improve our air quality. But we're at the point now where, number one, that air quality has improved dramatically to the point where it's actually quite clean. Vehicles have been for decades now manufactured in such a way that they cannot fail an emissions test. And MVA reports to us that 94, as of a couple of years ago, the report I'll refer to, MVA and MDE collaborated on a report that talked, number one, about the dramatic improvement in air quality, and number two, the fact that only about 6% of people who come to get their emissions test actually fail the test. And most of those failures, which is a small percentage already, most of those failures are not because their emissions were too high. It was because of a check engine light or some other sort of mechanical failure that then the person, regardless of income, need, or whatever, has to go and get addressed, usually at a tremendous cost, to then come back just to be told that their car meets emission standards because the car's manufactured to meet emission standards. We've created this sort of kabuki theater. It was not at the beginning, but now we're at the point where it literally is people paying a fee to do nothing. It doesn't do anything. And now the General Assembly, because of a budget crunch, increased the fee, which I think drew a lot more attention. In fiscal year 2026, it cost the state $20 to $21 million to run this program. Now, the state does bring in, with the increased fees, is going to be bringing in about $50 million, and it may grow some over the next few years, although cost will grow to run the program. So you're talking about maybe a $30 million net. But what's really interesting, and the fiscal note actually lays this out, over the next few years, it says that that net will grow some, although the costs don't seem to grow much. But what's interesting is that most of that profit margin they acknowledge is fines and fees that people are paying on top of the fee. So we've created this trap for people where they have to go once every 2 years with each of their vehicles pay this now $30 fee. If there's anything wrong with their car that keeps it from getting a reading, they have to go, sometimes if they're late, they have to pay a fine, or they have to go get a mechanic to deal with a fuse issue. And what they end up having is this trap where we're taking in more money for something that is not doing anything for the environment now. They're paying to simply prove that they have a modern car. And I believe firmly, and that's why I'm proud. I'm actually proud to have co-sponsors on this, including Senator Lamb, who I was pleased joined on with me as a co-sponsor, because we believe that if the state is taxing people under the guise of taking funds, under the guise of improving the environment, they ought to be paying for something that improves the environment. So I put this bill in because there's really three reasons we should pass this bill. One, this testing regime is no longer needed. It's no longer needed. Our air quality has improved dramatically, continues to improve from as far as what emissions can affect. Number two, and also it's no longer needed because cars that are all manufactured now do not, it's impossible for them to fall below the emissions threshold or rise above the emissions threshold. Number two, this is not a fair fee to drivers. We have made it incredibly hard to be a driver in this state, incredibly expensive. And this is only a small fee, but it is an inconvenience. It's a fee. And if you have some snafu where you have a problem or you forget about it, you're paying even bigger bucks. It's $30 each car every 2 years. But not all counties have to do it, which might have been a fair argument back when we were dealing with smog and when cars were not emissions efficient, but they are. So we have not everybody in the state has to do it. Only 14 of our 24 counties have to do it. And as I said, no one is failing. Functionally, nobody is failing. So we're making people do all of this when nobody's failing, essentially. And we really have reached a moment with this program where we should declare victory and get out, as they used to say about wars. We should declare victory, and let's pivot to doing other things. I guarantee you the $20 million cost every year that we put into this, some of it's contracted employees, but there are state employees involved. In most cases, it's contractual, but the state owns the land. So I guarantee you there's a better use for that $20 to $21 million. And so those are all factors to me in why this would be a great time as a gesture to Marylanders. We've just doubled and tripled car registration fees. Our gas tax goes up every year. And so from my perspective, this would be a great time for us to give a gesture back to people and say, it's time to give you a little bit of relief. So with that, Mr. Chairman, I'll take any questions that are available.
I'm going to, for the first time, have an amendment to co-sponsor and sign on to a bill with you.
I don't know if it's the first time, but it hasn't been many times. It's true.
I think so.
Well, great. Well, you know, every once in a while, blind squirrels find a nut, right? So that's right. I was talking about myself, but that's fine. You're good. Yeah.
I'm not even going to comment on that one, but Senator Sindor.
So in looking at the, have you had an opportunity to see the testimony from MDE?
I have perused it, yes.
So it says that the bill would violate federal law and expose Marylanders to dangerous air pollution. Now, according to their testimony, we're part of the ozone transport region. And so I'm curious, they say that, all right, if we take this away, we have to find, I guess, some other type of air quality emissions reductions. Has that been identified?
I believe there is some interpretation there that there's room for, but we have a lot of other programs that we could, I believe, address that issue. And speaking to them, exposing Marylanders to dangerous air quality, we've got to get back to like the reality-based community. Almost no cars on the road are emitting the kind of emissions that expose anybody to anything. So I'm happy to work with the department on it. They obviously oppose it because they oppose it. But to me, we have a number of programs in this state aimed at different types of air quality measures. I think we can find the way to assuage the federal concerns about that. And I believe, I believe there's a need to modernize some of that as well. Obviously, we do have to work within the confines of federal requirements. Yes.
Gotcha. Thank you.
Good afternoon, Senator.
Did you want to co-sponsor too? Or?
No, sir, I do not. That blind squirrel is not going to find this nut. So the reason we have better air quality and cars meeting this standard is because over time, the emissions standards have become stricter. And we have been pushing the auto industry to create more fuel-efficient vehicles and cleaner fuel. In light of the current administration's efforts to roll back emissions regulations, it seems to me that your statement that our cars are clean so everything's great might not be the case in the future. So can you tell me how, if we were to do this, and the administration is successful in continuing to roll back emission standards, how can we make sure that our air is clean?
Well, I would argue a lot of what they're rolling back is stuff that was implemented in the last administration. And I'm not going to go down the list because I'm sure that there are things that we could quibble over whether that was a Biden era thing or not. There's been a number of very restrictive and regulations that have come out recently from the federal government, and by the recently, I mean in the last few years, that added tremendous cost to vehicles. The emission standards that we've been under, though, for a long time, I don't believe are going anywhere. We obviously could always come back and look at things if that were to change. But to me, we've been taxing Marylanders now for multiple decades on something that the state itself admits basically nobody fails. We've been taking money out of people's pockets. And I just think it would be time to end that and try to look at ways to give some relief. Obviously, the federal government could always do something. I have a feeling, though, if you were to be ending emissions, like all emissions requirements, that would not be a politically tenable thing for any administration to do. I think what they're rolling back are some things that went, maybe, depending on your perspective, went so far that it made trucks, cars a lot less affordable. Obviously, that's a different discussion and debate, which we always enjoy doing. But I'm not concerned about it. And I feel that, again, we've been overcharging people for a long time in this program, from my perspective.
Thank you. Thank you, Mr. Chair.
All right, seeing that there are no more questions, I guess that's the end of this. That ends this hearing. Thank you very much.
Thank you.
All right, Senator Watson, all right, there we go. On Senate Bill 275.
Well, good afternoon, colleagues. Good afternoon, Mr. Chair, Vice Chair. Senator Watson, 23rd Legislative District for the record. Mr. Chair, thank you for the opportunity to testify in strong support of this Senate bill, Vehicle Laws, Electric Vehicle Dealer Licenses, City of Bowie. This legislation makes a modest but important change in Maryland law by increasing the number of electric vehicle dealer licenses allowed in the state from 4 to 5, and ensuring that the additional license may be issued specifically for the operation of an electric vehicle dealership in the City of Bowie. Maryland's EV market is growing. Access must grow too. Electric vehicles are no longer a niche market. Thousands of Maryland residents now drive EVs, and the number continues to rise as we work towards cleaner transportation, reduced emission, and energy independence. However, Maryland's current dealer licensing structure does not reflect this reality. State law currently limits these licenses to only 4 locations statewide, which has resulted in EV dealerships being concentrated in only a few parts of Maryland. At present, residents, particularly from my district, must travel significant distances to reach service and support because dealerships are located primarily in Owings Mills, Rockville, Frederick, and Silver Spring. This leaves large regions of the state, including Prince George's County and the Bowie area, without reasonable access. So this, for me, is an issue of fairness and equity. Bowie is one of the fastest growing and most diverse communities in Maryland. Many residents in my district already drive electric vehicles, yet they must travel long distances simply to obtain basic services such as warranty repairs, software updates, vehicle maintenance, customer support, and EV education. This is not just inconvenience, it is inequitable. Access to clean transportation infrastructure should not be limited to a handful of communities while others in the region are left behind. This bill makes a targeted, responsible adjustment. This bill does not eliminate the licensing framework. It simply adjusts the cap from 4 licenses to 5 and ensures that the additional license is designated for Bowie. The bill continues to maintain important safeguards, including that the manufacturer distributor must deal only in electric or non-fossil fuel-burning vehicles and cannot already have franchise dealers in the state. The economic and local benefits establishing this in Bowie would also bring significant benefits, including new local jobs, increased commercial investment, enhanced consumer choice, and strengthening Bowie's role as a regional transportation hub. In conclusion, members of the committee, Maryland has embraced the transition to electric vehicles. Now we must ensure that the infrastructure, service access, and consumer protections keep pace with that transition. And by authorizing 1 additional EV dealer license and designating it for Bowie as a location, it promotes fairness, supports EV drivers, and ensures that Prince George's County residents are not left behind. For that reason, I respectfully request a favorable report on this bill. Thank you for your time and consideration. And I have with me Bowie City Council member Roxy Ndimamadu to testify. You ready? All right.
Actually, can she take
She's gonna come up here?
Absolutely.
Okay.
Thank you.
Thank you so much, Senator Watson. Chair, members of the committee, good afternoon. My name is Roxy Ndimamadu. I have the pleasure of serving on the Bowie City Council and representing one of the most amazing cities in all of America. I want to briefly share how this issue surfaced. There are tens of thousands of electric vehicle drivers moving through our corridors every month. You see it with Rivians, Lucids, Teslas, yet there is no corresponding infrastructure. Maryland likes to lead. We lead in innovation, in clean energy, in the industry shaping what comes next. Leadership, though, isn't what we say. It's whether our systems allow progress to land. Right now, state law limits electric-only vehicle manufacturers to 4 direct dealer licenses. That number is historical. And after spending over 10 years in fast-moving technology markets, I've learned that fixed number caps ration access and delay service for constituents in markets that are already active. Bowie is where that misalignment shows up first. Not because we're asking for something special, but because of what Bowie actually is. We sit at the center of federal operations, regional transportation corridors, and daily use infrastructure. We are a city built for execution. When access to service, competition, and deployment is constrained, places like Bowie surface the friction immediately. SB 275 corrects that. It creates room for the market to function, for multiple EV manufacturers now and in the future to expand new service centers and showrooms where infrastructure, workforce, and demand already converge. This would also additionally bring up to $12K in additional revenue for the city of Bowie and align us with where the job market is already going, bringing service technicians, diagnostic engineers, logistics and fleet workers, and software-enabled operators to thrive. This bill removes a structural constraint. When Maryland aligns policy with how market already operates, innovation follows quickly and predictably. On behalf of the city of Bowie, we strongly support SB 275 and encourage you to join us in supporting that as well. Thank you so much.
Thank you. Senator Muse, did you still have a question?
He wants to sign on as a co-sponsor.
Your light was on before, is it?
Yes, it was. Hopefully, my light always stays on, but anyway, yeah, I was just wondering if this was just for the city of Bowie, but then I read here that what it's for. So that's it. Amendment on. That's fine. Thank you.
All right, I know Senator Love, she had it, but she's gone now, so.
Love is everywhere.
Thank you very much. We have one individual that has an unfavorable, Joshua Fisher.
Mr. Chair, Vice Chair, members of the committee, for the record, my name is Josh Fisher. I'm with the Alliance for Automotive Innovation. The Alliance is a trade association which represents the automobile manufacturers that produce the overwhelming majority of all cars and light-duty trucks sold in the U.S. Additionally, all of our members use a franchise dealer network across the country. I'm here to request an unfavorable report on Senate Bill 275 because it's going to exacerbate an already existing inequity in Maryland law that treats competitors in the same marketplace differently. There's no justification for companies like Tesla and Rivian to be exempt from the same franchise provisions that the overwhelming majority of market participants are subject to in Maryland. This is a clear case of favoritism and creates an unequal playing field in Maryland. The current franchise model works well for manufacturers, dealers, and consumers, which is why we support it. It's a long-standing and proven method for selling automobiles across the country. Maryland law does have this 4-store carve-out for direct sale EV companies. But this means that direct sale automakers operate under a different, less restrictive set of rules than legacy manufacturers do, and they have to comply with they don't have to comply with Maryland's complete auto franchise law. This is an unfair competitive advantage, and the state should not seek to make these inequities greater. There's nothing preventing a direct sale manufacturer from selling their vehicles through a franchise dealer model. They can do so today without needing a bill. Tesla can open up dealerships all across the state, all across the country if they choose to. They've chosen not to play by the same rules that everybody else does, and Maryland should not allow them to continue to do so. After all, direct sale companies make the same product that other automakers do, and they sell to the same consumer. Why does Tesla get a favored treatment in Maryland? We urge the committee to consider the principle of equal treatment for all competitors and request an unfavorable report on Senate Bill 275. Thank you.
Thank you. All right, I saw Senator McKay, then Senator Muse.
Thank you, Mr. Chair. So is it your testimony of unfavorable because of going from 4 to 5 or putting it directly in the city of Bowie?
We oppose direct sales in general. It's not the location. I bought my car in Bowie from a franchise dealer. I know there's plenty of them along 301. Tesla could set up a dealership tomorrow if they wanted to. So it's the principle of direct sales. Maybe 10 years ago when Tesla was the only player in the game, Maryland might have found a public policy justification for basically exempting them from the franchise statute, which is what they did. That does not exist anymore. Tesla makes the same product that our members do, and they sell to the same consumers. And so we oppose direct sales in general. It's not about Bowie.
Okay, and then so having 5 licenses versus 4, you just don't believe we need it to be in the beginning?
No, we think Tesla should be subject to the franchise statute like every other manufacturer. So we oppose direct sales. Frankly, we would prefer 0 licenses for Tesla.
Okay, that's what I was trying to get.
Yeah.
Thank you.
In reality, you want to be amended onto this bill, correct?
No, we don't want to sell directly.
Okay.
No, I know. It's a simple principle. All competitors, I know what you're getting at, I know, but no, all competitors should play by the same set of rules.
That's correct. Okay, that's good.
Are there any other questions?
Maybe another time.
Just one. Is Tesla the only organization that this would be applicable to? I mean, you kept mentioning them.
It would apply to companies like Rivian and Lucid, which are the 3 major EV-only direct sale companies in the market, so those 3 companies.
Thank you very much.
Thank you.
And on that ends the hearing for Senate Bill 275. Next, we'll have Senate Bill 285. Senator Carrozza.
Good afternoon, members of the Senate Judicial Proceedings Committee. For the record, Senator Mary Beth Carrozza, representing District 38, which is Maryland's coast, Worcester, Wycomico, and Somerset counties. And I am pleased to be here to present Senate Bill 285, which would allow for the eligibility for the scholarships, the Maryland Police Officers and Probation Agent Scholarships, to include correctional officers. The shortage of public safety professionals, including correctional officers, continues to be a challenge across the state of Maryland. And in my district, I have worked with the leadership of the Department of Public Safety and Corrections and with Eastern Correctional Institute, ECI, and my local detention facilities to increase the number of correctional officers, which I believe this committee will agree increases the safety of the facility and overall community safety. Over the years, this committee, and we have focused on recruitment and retention of correctional officers across the state, and again, in my district, ECI, and the county detention facilities. We look for opportunities to ensure that correctional officers are on par with the opportunities of other public safety professionals, and that is the intention of Senate Bill 285. The Maryland Police Officers and Probation Agents Scholarship Program provides tuition assistance to Maryland residents enrolled in degree programs that further a career in law enforcement or community supervision. And SB 285 would expand the program to include correctional officers. I would think this committee would agree that the best ideas for legislation often come from the front lines from our constituents, and that was the case when Shaitina Drummond, Assistant Warden of the Worcester County Jail and a member of the Maryland Correctional Administrators Association Legislative Committee, and I might add, a Stephen Decatur High School graduate, 15 years of experience at Eastern Correctional Institute and 6 years at the Worcester County Jail. She shared with me the recommendation to expand the eligibility of the Maryland Police Officers and Probation Agents Scholarship to include correctional officers. And as she will discuss in her testimony, this legislation would provide a tool for the recruitment and retention of correctional officers and would boost morale for current correctional officers. By extending these important financial incentives to correctional officers, we can strengthen recruitment and retention in a field that is critical to the safety and well-being of Maryland communities, as correctional officers are an integral part of Maryland's public safety network. Public safety personnel, including correctional officers, serve on the front lines of justice and rehabilitation, often under very challenging conditions and with limited career advancement opportunities without further education. Offering this education incentive can lower barriers to entering and remaining in these careers where we need them, ultimately contributing to a more effective and stable public safety workforce. I'd like to point out to the members that the legislation is supported by the Maryland Correctional Administrators Association, the Maryland Higher Education Commission, the Maryland Association of Community Colleges, and Warwick Community College, which I represent. I thank you for your kind attention and consideration, and I respectfully request a favorable and swift report on Senate Bill 285, an important public safety piece of legislation. Thank you.
Thank you very much. We'll finish the rest of the panel. Ms. Drummond.
Thank you, Senator Carrozza, Chair Smith, Vice Chair Waldstreicher, and members of committee for allowing me to testify on this important legislation, Senate Bill 285. For the record, my name is Shaitina Drummond. I'm an assistant warden at the Worcester County Jail in Snow Hill, Maryland, and a member of the Maryland Correctional Administrators Association. Today, I want to talk about an opportunity that can significantly impact all Maryland correctional officers. As it currently stands, there's a scholarship program that exists to assist with furthering the education of Maryland probation agents and police officers, while correctional officers who play an equally critical role in maintaining public safety are not receiving the same opportunity. Just like probation agents and police officers, we must also recognize the vital contributions of correctional officers. That is why I believe that this legislation is so important. By closing the gap, we can create a more cohesive and competent public safety community. Education is not just about personal growth. It is essential for effectively managing our correctional facilities. Offering tuition reimbursement through this scholarship program to correctional officers will empower them to develop professionally, which can increase public trust and safety in the correction system. Fostering career development leads to higher job satisfaction, increases morale and retention. This program would be a recruitment incentive, which can be promoted to attract new hires for our correctional facilities. Investing in the education of correctional officers will let them know that they are appreciated and that their work is valued. Furthering their education not only benefits correctional officers personally, but it also positively impacts the incarcerated individuals they work with. Better educated correctional officers leads to improved public safety and lower recidivism rates, which ultimately strengthens our communities. In conclusion, I respectfully urge you to support Senate Bill 285 by extending scholarship opportunities to correctional officers. You're acknowledging their significance and commitment to public safety. Together, we can pave the way for a better educated, more effective, and more inclusive corrections workforce. Thank you for your time and your consideration.
Thank you, Ms. Drummond. Ms. Ann Thompson? Oh.
Good afternoon.
Go ahead, go right on ahead.
Okay, very good. Good afternoon. I am Mary Ann Thompson, Warden of the St. Mary's County Detention and Rehabilitation Center and past president of the Maryland Correctional Administrators Association. The safety and security of those entrusted to our care are paramount. The old philosophy of lock them up and throw away the key is no more. Correctional philosophies have evolved into a health equity mission. Our facility must be safe and secure, providing therapeutic environments for the physical and psychological well-being of both the incarcerated individuals and those correctional professionals who walk, quite frankly, the toughest beat in America. The Maryland Correctional Administrators Association, MCAA, views education as a key driver of public safety within Maryland's correctional system. Advanced education strengthens correctional officers' leadership and decision-making skills, enabling them to effectively manage high-risk environments, de-escalate conflict, and maintain secure facilities. Research and experience show that a more educated correctional workforce improves institutional safety, reduces incidents, and promotes professionalism. The Maryland Correctional Administrators Association respectfully requests that Senate Bill 285 be passed and supported by the committee. It is important to remember that if you have visited one jail, you've only visited one jail. I personally extend an invitation to visit any local detention center in Maryland, and I'm thankful for the opportunity to provide testimony. So thank you.
Thank you. Do we have any questions from anyone? I do not see any questions about this bill, but if I may ask, earlier this afternoon, and you are with the Maryland Correctional Administrators Association?
Yes, me and Deputy Director Drummond both are.
Great. Earlier this afternoon, there was some testimony about our prison systems, and the representative from the Maryland State's Attorneys Association has said that the adult system is for punishment. I know that there's been a debate whether or not the system is for rehabilitation or punishment, but is that the official policy of the state of Maryland, that the adult system is for punishment?
No, sir. We are not here to punish people. That is not our job. The courts and judicial systems, they decide the punishment. We are not here for that. We are here, and if you can look at the name of our detention center, it includes rehabilitation. And you know, in St. Mary's, we're very, very strong proponents of community corrections. And our goal is when we return people to the community, that they have all the tools that they need to be successful. And our goal is to make it better for the children and the offenders' lives as well. So I respectfully disagree with what was put forth this afternoon. And, you know, I feel like it was a missed opportunity, or maybe an opportunity to be able to work with the state's attorney's office to show that we work very hard for rehabilitation in our local detention centers.
And that's what I thought, and I appreciate you taking the opportunity to share that with me. With that, we are finished with Senate Bill 285. Senator Crows, I believe you have 367. Are you ready for that?
I do.
All right, floor is yours.
Good afternoon again, members of the Senate Judicial Proceedings Committee. For the record, Senator Mary Beth Carrozza, representing Maryland's Coast District 38. And I am now presenting to you Senate Bill 367, which is a local bill, the Wicomico County Highway Pedestrian Safety Act. And I want to thank the committee members for your past support of this legislation, and which unanimously passed the Senate last session and was being considered on the House floor, and we ran out of time as we worked through an issue on the House side. This local enabling legislation would prohibit a person from standing in a roadway, shoulder, medium divide, or intersection determined by Wicomico County or a municipality in Wicomico County to be inherently dangerous. An individual who stands in a roadway poses various challenges and risks to themselves, the drivers on the road, the responding officers, and the surrounding community. Chief Mindshine will go into more detail, but since 2022, the Salisbury Police Department has responded to 457 calls for service related to highway and pedestrian safety issues. And among those in the past year, 120 calls alone, 45 of those calls were for impeding traffic. There have been instances where the individual places him or herself directly in front of an incoming vehicle, and situations where students are placing themselves in danger by fundraising or whatever in the roadways. And so you will hear it's been a reoccurring public safety issue, and that's why we are back again this year to pass this local Wicomico County public safety bill. This committee knows that while Maryland law contains general pedestrian and traffic safety provisions, existing statutes do not adequately address this specific and escalating conduct. Passage of this legislation would enable officers in Wicomico County to deter hazardous roadway behavior, make appropriate contact with individuals who may be in crisis, connect them with available services, and engage mental health co-responder teams when appropriate. Most important, it will enhance roadway safety for everyone who travels throughout our community in Wicomico County. Mr. Chair and members, it's important to note that Senate Bill 367 does not criminalize individuals who are soliciting donations. And I want to stress that the intention, this is fully intended to increase public safety by ensuring that these individuals are not standing in the roadways for whatever reasons because of the danger involved. Just a little bit of background. I believe this committee knows that this legislation, not only was it previously introduced for Wicomico County last session, but there are similar statutes in effect in Carroll, Charles, Harford, and Washington counties. During the interim, I worked with Delegate Vaughn Stewart and the council from the House Transportation and Environment Committee, and in coordination with council here, to discuss the best path forward to pass this important local public safety legislation this session. And so the topic of solicitations in roadways apparently has received conflicting opinions from the Office of the Attorney General over the years. So what we did over the interim working through this issue is that this Senate Bill 367 is content neutral to address any questions that were raised in the past, and it does provide this important public safety tool for us in Wicomico County. Again, it would simply prohibit a person from standing in a roadway determined by Wicomico County to be inherently dangerous, which means posing a serious risk of injury to a pedestrian, a driver or passenger in a vehicle, or other persons that cannot be mitigated with the exercise of ordinary care. The definition is in the bill. I would like to point out again, we have continued and strong support from the Salisbury Police Department, from the Wycomico Sheriff's Office, from the Wycomico County Public Schools, from Salisbury University, from the City of Salisbury, from the Wycomico County Council, the Wycomico County Executive, and the Wycomico County State's Attorney, all working together to reach this point, to introduce this bill again and to push it over the finish line this session. So with that, members, I would ask for a favorable and very swift report for Senate Bill 367, the Wycomico County Highway Pedestrian Safety Act, which is a priority local public safety bill. Thank you, and I have with me Chief Mindshine, who's come up from Salisbury to join us.
Thank you, Senator Carozza. Mr. Chair, members of the committee, thank you very much. It's an honor to be here for you today to give testimony in favor of Senate Bill 367, Wycomico County Highway Safety Act. Just to reiterate what Senator Carozza had mentioned, between the dates of January 2022 and December 2025, the Salisbury Police Department has experienced over 450 calls for service related to solicitation, including incidents that directly affect safe flow of traffic flow in and around dangerous roadways, the shoulders, roadways, and intersections. Just this past year in 2025, including those numbers, were 120 reports of traffic safety related incidents. 45 of those incidents, or 37%, were reported to be for solicitors either acting in an aggressive or intimidating manner or were directly impeding traffic flow. In several incidents that occurred on October 15th last year, after a motor vehicle operator did not comply with the solicitor's demands, was confronted by the solicitor who stated in a threatening manner that he was going to kill the operators of the vehicles. In 3 additional occurrences, one occurring on June 21st, September 3rd, and October 11th, respectively, aggressive solicitors were arrested for disorderly conduct or having active arrest warrants on that day in separate locations. Although we're sympathetic to the motives of solicitors in some cases, given the number of reported increasing incidents we're experiencing in Salisbury, it's just a matter of time before a situation occurs in which a solicitor that is in close proximity of a roadway or in a roadway is struck by a motor vehicle or involved in an incident that escalates into a physical assault or a worst case situation. Many of these areas are also located near the hospital, trauma center, or the Salisbury State College. And I believe that authorizing police officer in Wycomico County to enforce Transportation Article 21507.1 will enhance public safety on our roadways and may open avenues for enhanced resources for solicitors through court diversionary and police mental health co-responder program, which we have an active co-responder program.
Thank you, sir.
For all those reasons, I'm asking for a favorable vote towards passing this legislation. Thank you very much.
Thank you very much. Senator
Thank you for
Love.
allowing me to go over.
Thank you, Mr. Chair. Thank you, Senator, for bringing this bill. And I appreciate the work that you did with our colleagues over in the House. Just a quick question, because I'm a little confused with, I'm sorry, could you remind me your rank? I don't want to misstate.
I'm the chief.
You're the chief. Okay, thank you, Chief. I'm a little confused about, Senator, how you presented the bill and how I read it with what the chief was saying, because Chief, you seem to focus on solicitors, which seemed to be last year's bill, and as I understand it, this bill this year is content neutral. It's talking about the intersection being dangerous, not the individual being dangerous. So I want to make sure that I understand the bill correctly. The bill this year is the intersection is deemed inherently dangerous. It doesn't matter if it's an aggressive solicitor or the firefighters out there with their boots, anybody in an inherently dangerous intersection is the one who would be cited, as opposed to sort of a solicitor who is getting aggressive but not committing any crimes or threatening anybody on a different roadway. Is that correct?
I think the, in my opinion, the individual that is in some of these locations around, and some of like I mentioned, around the college intersections, some of these up on our north end of town, our business districts are inherently dangerous locations anyway. I think the intersection itself, some of these intersections are inherently dangerous by the virtue of the traffic flow, but these individuals, in a lot of cases, target these intersections, which compounds the issue because of the large traffic volume. So it's really twofold. It's the intersection itself is dangerous, and the individuals have the propensity to be at some of these locations because of the large traffic flow soliciting, if that answers your question.
Thank you. Thank you, Mr. Chair.
Thank you. Now, just following up on what Senator Love, so this is not the bill that we voted on last year. This is a different bill, but is that the case?
The bill still accomplishes what we passed last year, was to have, to be able to prohibit an individual from standing in the roadway. So, for those reasons, what we did is made it less about the reason why they were standing in the roadway and made it content neutral. So we're still trying to accomplish the same public safety goal, but we moved away from, I guess, that focus on why they might be in the roadways, so there weren't questions about the First Amendment and constitutional issues that were raised on the House side. And we worked very closely with Delegate Vaughn Stewart and with counsel, and we had some assistance with a local attorney from the state's attorney's office to try to make sure that we could both have that public safety, keep that public safety piece, but not come up against these, quote, questions of, constitutional questions that were raised by, I guess, in past opinions by the Attorney General. So that's why we worked through the bill, but it has the same intention, which is to prohibit these individuals from being in the roadway, within these inherently dangerous areas.
But in making it content neutral, would you agree that this is now a broader bill that could capture anyone that's on these?
No, so there were questions raised in the past, whether it was a firefighter that had a boot out, whether it was a student, which is why you see the testimony from the school system in Salisbury University, if it was enthusiastic students trying to raise money in the roadway, whether it was somebody who might have some behavioral challenges and maybe in the roadway for those reasons. So it was really to make it the broad prohibition, make it very clear. Not so much the reason why they were in that roadway, but that they shouldn't be in the roadway to begin with.
All right, but with last year, there had to be some other prong you had to be soliciting. Now it's anyone that's in this inherently dangerous or this identified inherently dangerous roadway, shoulder, median, divider, or intersection. Am I reading it? Is that right?
And yes, we're trying to prohibit anyone for any reason not to be standing in those inherently dangerous areas.
Mr. Chief, how do you see yourself enforcing this statute? Who's the target?
Yeah, our goal, Mr. Chair, our goal is, honestly, what we're trying to do is reduce the risk of an accident and of aggressive behavior, like I had mentioned. Our goal is not to issue the citations, but we want to use it as an additional tool to have, in case we're pushing a situation of repeat offenders that are in some of these intersections, inherently dangerous locations, to deter them from that location. Also to, again, be able to engage our co-responder of the state's attorney's office through the citation for perhaps a diversionary program, bring to bear some possibility of a diversionary program, perhaps, and just be able to engage further with them. So that is also part of it. But to unlock, I guess I should say, the intersections that I'm referring to down near the college on the north end, where we inherently see a large amount of these people, folks soliciting and so forth. it's hard to separate the two. It's hard to separate the fact that it's an inherently dangerous intersection because of the traffic flow and these folks knowing to go to these intersections because of the traffic flow and their ability to garner favor at those locations.
All right, so we understand median divider, that's just standing on that little strip of concrete in the middle of the road. The shoulder is still in the street, but it's on the side of the road, is that correct?
It is, but there are occasions where if someone's in the shoulder, on occasion they're reaching out into traffic and so forth, they're walking up to vehicles, leaving the shoulder, going into the road and back. There are quite a few times where folks are reaching out or whatever as the light changes, traffic's moving and so forth.
How about on the sidewalk of the road, not in the median, but on the side, on the sidewalk?
It's dependent on the intersection location. They're all designed a little different, but there is certainly the possibility, but it's really geared towards if it's a dangerous location, dangerous intersection. It's not necessarily to if someone's standing there and they might be soliciting, but they're not presenting an active area where it could be deemed dangerous or in the roadway or near the roadway, whether it be a shoulder or medium. We're not looking at targeting those type of areas to try to restrict that. What we're looking at is the individuals that if they pose, they add to the issue of the inherently dangerous location. They're adding to the problem.
And one last question. I'm assuming there's a process that the county would have to go through in order to deem one of these places to be inherently dangerous. What does that process look like, and what is it that you're going to use to determine whether or not it's inherently dangerous?
We hadn't got to that point of that discussion point, but that would not be a heavy lift to identify the locations that we would deem. It would be very easy to do that. So
then I guess the public would then get some sort of notice, and then you put out the signage.
Yes, absolutely. As the senator mentioned, it would be signed as the bill requires.
All right, I appreciate it. Thank you very much. That ends the testimony on Senate Bill 367. Next, we have Senate Bill 310, Senator Jennings.
Thank you, Mr. Chair, distinguished members of the committee, Senator Folden. It's good to be here. For the record, Senator J.B. Jennings, District 7, proudly representing Baltimore and Harford County. I bring before you Senate Bill 310, deals with traffic violations in minors. As you know, and when it deals with minors, a lot of their cases are shielded. The public can't get access to it. But what we found is it does not apply to traffic violations. This case came in from a constituent of mine whose son unfortunately got in trouble riding an e-scooter, and come to find out, all his information was then able to go through judiciary case search and find those offenses. And we're always working hard to ensure that our youth are protected. And we found is that, unfortunately, if it comes to a traffic violation, they're not. It is public. I do understand that places like insurance companies and others need to access that stuff to be able to see their driving record for regards to insurance rates. I know that there's a bill in from Senator Washington that deals with Baltimore City, allowing some information to be shared. This bill, as you can see, it's a pretty short bill the way it was drafted. It is not in the form it needs to be. I think it does need some work to say, hey, look, in these cases, you can provide that privately to an insurance company or other agencies that need to see, a youth's driving record. I know the courts have come out against the bill saying that they can't shield because of the date. But you know what? We shield on other reasons for juveniles. Why not fix it that way? But, again, remember, the name, the birth date, and the home address are all public to anybody that wants to go in case search. Additionally, it follows them into their older life. 16, 17-year-old drivers don't make the smartest decisions in life, just like we shield, crimes that kids are convicted of. You know what? Sometimes it's like looking at the driving records, hey, it's youthful indiscretion. But the big thing is making sure that the records are sealed while they're, or privatized while they're, or closed to the public while they're a juvenile. That is the bill. Again, I don't think it's drafted correctly. We got it in, and this is where we are. But, I leave it to the wisdom of this committee to look at it and say, hey, I think we need to fix this, and let's work on this legislation. So with that, I ask for a favorable consideration.
Thank you very much. Senator Folden.
Thank you, Mr. Chair. Thank you for bringing the bill, Senator. I just wanted to point out that most traffic violations are considered misdemeanors, correct?
I believe so.
Yeah.
Unless you.
So I was kind of piggybacking on what you said, because I think sometimes we only think of them as civil, but any traffic violation has an offense category that could be punishable by jail time.
Yes.
So it makes perfect sense. So I'm glad you brought the bill forward. So thank you.
Thank you, sir.
All right. Next, we have Mr. Rick Heyman, who is going to testify favorable, and he's virtual.
Are you guys able to hear me?
Yes, sir.
Yes, sir.
Okay, great. Thank you. Thank you so much for the honor and the privilege of being able to have input into this bill, SB 310. This involved an incident with my son, who was actually 15 years old at the time, up here in Harford County. And we were on a semi-rural road. He was doing a wheelie.
Mr. Heyman?
Yes, sir.
Is it possible to turn your camera on? We don't see you.
I thought the camera was on. How's that? Can you see me now?
No, sir.
Not yet. We're trying.
Okay, let me see. Because I had reached out to Senator Jennings' assistant, and that I was having trouble with Zoom this morning.
All right. Never mind.
Let me see.
As much as we want to see your face, go right on ahead. I'm sorry.
Okay. Are you able to see me now?
No, sir. It's still black.
Yep.
Oh, there you are. There you are.
Okay.
Thank
I'm
you.
sorry. I apologize. I'm on my phone. Let me go back and say that I am privileged and honored to be able to have input into this bill. This bill will not help me or my son, but it will help juveniles going forward. Am I able to speak freely now?
Go right on ahead.
Okay. My son, Benjamin Heyman, is a little bit of a rebel, and I've had a little bit of a difficult time. He's on a straight path now. He's going to electrical school. He's 19 years old now. However, at the age of 15, he was riding an e-bike, an electric bike that didn't go above 25 miles an hour. He was on a semi-rural road doing a wheelie when a Harford County sheriff observed him and tried to stop him. And because he was fearful that his bike was going to be confiscated, he took off. Now, because these teenagers all think that they're going to be YouTube, millionaires these days, he posted it on his YouTube channel. And 11 months after the incident, keep in mind he was 15 years old at the time of the incident, they came back and they charged him with reckless driving, fleeing and eluding, and operating an unregistered motor vehicle. It's hard enough getting through high school as it is, but because the Maryland case judiciary had his license, his information, his date of birth, and most importantly, his address was put on the website for all of his classmates and his teachers to see what he had gotten into. I just don't think it's fair that a juvenile's information is posted on judiciary case search, regardless of whether it's a traffic violation or a criminal offense. And as a former police officer 35 years ago, I know that juveniles' information is protected. So I firmly believe that, like, under these circumstances, you should not be posting the juvenile's, personal information on the website. And that's all I have to say. Thank you so much.
Thank you for your testimony. Seeing no questions. Thank you very much, Senator Jennings. That ends the testimony for Senate Bill 310. Next, we're going to have Senator Washington, Senate Bill 349.
Thank you, Mr. Chairman, Mr. Vice Chairman, members of the committee. For the record, Senator Alonzo Washington here to speak on Senate Bill 349, Vehicle Laws and Eluding Police Penalties. This bill, once passed, I'm hopeful to be called Zoe's Law. Zoe Harrison was 3 years old. She was riding in the back seat of her mother's car when a driver fleeing a police traffic stop crashed into them. Zoe did not choose to be a part of a police encounter that day. Her family did not choose to be a part of a police pursuit, but their lives were permanently changed by someone else's decision to flee. This bill today addresses a narrow but serious gap in Maryland law. When someone makes the deliberate decision to flee police and that decision results in the death of an innocent person, our law should treat that conduct with appropriate seriousness. Fleeing the police is an intentional act. When that intentional act results in the loss of life, current law classifies that offense as a misdemeanor. That classification does not reflect the gravity of the harm caused or the risk imposed on the public. This bill corrects that. SB 349 reclassifies attempting to elude law enforcement resulting in death from a misdemeanor to a felony. It does not create a new offense. It does not change the elements of the crime. It only adjusts the penalty to align the outcome when the most serious harm occurs. This bill only applies when a death occurs. It does not apply to routine traffic stops. It does not apply to injury pursuits. It does not create mandatory minimums. This is a targeted response to Zoe's situation, not a broad expansion of criminal liability. Also, SB 349 does not affect police pursuit policies. It does not direct officers to pursue or disengage. It does not incentivize chases. Those decisions remain governed by existing departmental policies and training. This bill addresses post-incident accountability, not real-time policing. National data consistently shows that bystanders make up a significant share of pursuit-related fatalities. In Prince George's County, where Zoe was unfortunately killed, they adopted Zoe's law to improve pursuit decision-making and transparency after the death of that 3-year-old. SB 349 complements that local reform by addressing the state-level criminal classifications when flight results in death. Nothing in this bill shortcuts due process. Prosecutors must still prove the underlying offense and the causal connection. Courts retain sentencing discretion. Defendants retain all procedural protections. Nothing in this bill, again, shortcuts the due process. This bill is narrow, proportional, and carefully drafted. It respects police discretion, preserves due process, aligns our law with the seriousness of the harm when flight results in death. For those reasons, I respectfully urge a favorable report on Senate Bill 349. Thank you.
Thank you. Any questions? Seeing no questions, I believe we have Mr. Yates. Is Mr. Yates here? All right. And then after Mr. Yates, we'll have Robert Hill.
Good afternoon again, Mr. Chairman and committee members. I'm Chief Stephen Yates of Northeast Police Department, representing Maryland Chiefs of Police Association and the Maryland Sheriff's Association on Senate Bill 349. We support this. We think it's a good idea. It holds people accountable when they flee from the police. It is a meaningful penalty to make this a felony instead of a misdemeanor, and we're in support of it. So, thank you. Any questions?
I'm sorry, did you finish?
Yeah.
I'm sorry, thank you.
It was quick.
Thank you very much. Mr. Hill?
Good afternoon, Senator Sidner. Robert Hill on behalf of the Maryland State's Attorneys Association and the Montgomery County State's Attorney's Office. I'm a prosecutor there. I'm testifying in opposition today, and what I'm concerned about is that under current law, the penalty is 10 years and or a $5,000 fine. What this bill proposes to do is to reduce that penalty to 5 years and or a $5,000 fine. It does provide for a second offender or a subsequent offender a penalty of 10 years and a $5,000 fine. I'm very concerned about reducing the penalty. I mean, when you've got a situation like what happened to Zoe, it's very serious, and a judge should not be a judge should have discretion to be able to impose a sentence that is appropriate under those circumstances. Whether or not it's a felony, I can just tell you, I come from an office, John McCarthy, state's attorney there, would not be concerned about whether it was labeled a misdemeanor or a felony. What he'd be concerned about is the penalty itself. And I noted, just as an aside, Senator, a good number of the a large percentage of people who flee and elude police are under 25 years old. And in some instances, it might saddle an 18-year-old with a felony at a young age. And down the line, when they're trying to get a job, when they've turned their lives around or whatever it is, it just doesn't seem to make sense. I think the penalty is what we're mainly concerned about. So I would urge an unfavorable report. Thank you.
Thank you very much. We have a question from Senator Folden.
Thank you, Mr. Chair. Mr. Hill, are you testifying as a part of the State's Attorneys Association, or are you testifying as yourself?
I'm testifying as a part of the State's Attorneys Association. I would tell you that the felony aspect comes more from my office, from Mr. McCarthy, but we are opposed to reducing the penalty.
Yeah. So if there was an amendment from the sponsor, say, that would make it consistent with the time frame of 10 years, I'm sure that was not done intentionally, but would make it a felony to be involved in a vehicular pursuit. Again, like you said, not changing any of the police dynamics, not changing any of their policies, but should that pursuit result in the death of another person, an innocent being, would your agency then have a problem with changing it to a felony?
No, what I don't want to trade is I don't want to trade the penalty for just labeling it a felony, which doesn't make a lot of sense to me.
Completely understand. I just wanted to make sure that if you were amenable to, and it appears the sponsor's good with making it, again, I think it was just a simple oversight. I don't think it was anything like intentional. But if that's all we have to do, I think it seems that the sponsors would be good with that. And then you guys would come in line with, as a favorable with amendment. Is that fair?
Yes, that is fair. And in that instance, with an amendment, we would support it.
Okay, great. I appreciate it, Mr. Hill. Thank you.
Senator Wallstreicher.
Thank you, Mr. Chairman. Hey, Robert, it's Jeff Wallstreicher. So,
Senator, yes.
How do you charge this now, just hypothetically? In other words, if there's fleeing and eluding and a death and what you and I would consider egregious behavior, I'm just curious, how would you, under current law, try to get at the accountability that this bill is trying to get at?
You know, it depends. It depends essentially on how it happened. You know, for example, if the person who's fleeing is driving 100 miles per hour in a school zone and strikes somebody in doing that, you would have potentially depraved heart murder, or you would have manslaughter. In addition to this, this would probably not be the primary charge. If you had a situation where a police officer strikes another car and kills somebody in the process of chasing somebody, that might change. I will tell you that I don't do these, what they call collision reconstruction cases. I haven't done them in a long time. So probably one of my colleagues who's on that team would be better equipped to answer that aspect. But I can just tell you if it's a person who causes the accident, and is reckless, disregarding human life, they would be charged accordingly with depraved heart. In addition to this.
All right, that looks like the end of questions. Thank you very much. That will end the testimony on the bill hearing for Senate Bill 349. Is Senator Kagan? All right, Senator Kagan for Senate Bill 354.
Thank you, Mr. Chair. Colleagues, good afternoon. For the record, I'm Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville. 10 years ago, our friend and colleague, Senator Simon Ayer, brought a bill that passed through the Senate and the House, both unanimously. And that was to tweak the level of disbursements, the threshold for nonprofits required to submit audits, either a full, complete audit or kind of audit light. In 10 years, obviously, the cost of living has increased. Obviously, the burden on our nonprofit organizations and their overhead has increased. And we believe, as does Maryland Nonprofits, believe it's time to revisit and tweak once again the level required for, that requires and triggers an audit. Let me just say that 27 other states have requirements for audits, that 14 states have it at the level that we are proposing. There are 4 states that are higher than the $1 million level, but 10 years is a long time. So among the folks endorsing this bill and this modest increase is the Chamber of Commerce, and they said, in Maryland, nonprofits are a major economic force, employing more than 280,000 workers, that's in Montgomery County, and contributing billions of dollars annually in wages, revenue, and community services. So we believe that nonprofits should be in compliance and be able to focus on their missions in this time of need. When they have to hire an auditor and take the time away from their mission to deal with accounting and all of that, it not only affects their bottom line, but it affects their ability to serve our community in these challenging times. It's a really simple bill. I just will remind you that our Secretary of State can ask for an audit from any nonprofit at any level. So this says that if you have $750,000 right now, that's the current level of revenues, then you have to do a complete audit. This would raise it to $1 million. So it's going to make it a little easier on some of our mid-sized nonprofits. For the audit light, it'll go from $300,000 to $500,000 is what this bill suggests. So again, the Secretary of State can ask for an audit from anyone at any time. This is just going to change the default for the first time in 10 years. Happy to take questions, and I have Henry Bogdan from Maryland Nonprofits as my one witness, so as not to take your time on what I know are always long days in judicial proceedings.
Thank you very much, Mr. Bogdan.
Thank you, Mr. Chairman.
Would you mind?
You want to come here?
Told you I could.
Oh, ASL interpreter? Wait, hold on. Just want to make sure that if we have an interpreter. Okay, we're good. I clicked on it. Sandy, good?
Thank you, Senator. Members of the committee, my name's Henry Bogdan. I'm the policy director at Maryland Nonprofits. I supported the bill 10 years ago, submitted by Senator Simon Ayer. We're supporting this bill. The cost of living, the cost of financial services have accelerated. That's been, if you take 3% a year compounded, you've got an increase that we think really makes this desirable. You have written testimony from other nonprofits talking about the burdens beyond even the cost of paying the auditor, that this takes up time of their financial staff if they have to do a full audit. The financial stresses on nonprofits are greater now probably than any other non-recessionary period I can remember. So we're asking for this relief. My understanding from the Secretary of State's office is somewhere north of 1,500 to 1,700 organizations would save significant money with the passage of the bill. So we urge support.
Thank you very much. Are there any questions? Seeing no questions, thank you very much. That ends the hearing on Senate Bill 354. Next.
Thank you very much.
Thank you. We have Senator Wallstreicher for Senate Bill 366.
Thank you, Mr. Chairman, and my advocates are coming in from the holding room and happy to describe the bill before us. I wish Senator Muse were here because he was very kind to invite me down to his legislative district to talk about the issues on Route 201, Indian Head Highway, certainly the most dangerous road in the state, as we have heard so many times, possibly the most dangerous road in the nation. And the Prince George's County Police gave a presentation to the community. It's an incredible community. Everyone is activated on this issue. Just to be clear, this bill is statewide, but I'm using 201 as an example. And I think post-COVID, there's this notion that kind of everyone is driving fast and everyone's driving pretty crazy and we've all kind of lost our minds. And I feel that too. But it turns out that that's not actually the case. That's not what the statistics show. Of both the automated and the police stop data from Route 201 in Prince George's County, of which there is much, turns out most people, overwhelming majority, drive the speed limit. But there's a small proportion of people who are driving incredibly dangerously. And they are the source of so many of the deaths and injuries and accidents on our state roads. And if you extrapolate it, and I'm pretty sure the data for the entire state would show the exact same thing, what we now realize is there is a small portion of people that we need to hold accountable or provide solutions by which they can drive the speed limit and come into compliance with our rules and laws. We've done this in another area, and this is the most important analogy for this bill. Most people don't drive drunk. It's a terrible mistake. Now you can get an Uber anyway. There's been huge educational campaigns, but a very small proportion of people continue to drive drunk. And for them, we often mandate an alcohol interlock so that they can't physically drive the vehicle while intoxicated. And courts will sometimes require that people install these in their vehicles. So we have two similar problems. A very small proportion of people doing very bad things. And on the alcohol side, we have a very clear solution, an interlock. So let's extend that analogy. What if there were essentially an interlock for super speeders? A technology that is analogous to a breathalyzer interlock, but applied to people who have gone far beyond the cultural norms of how we drive on our roadways. Well, it turns out there is such a technology. It's called an ISA, and it can be installed in vehicles to prevent people from going substantially above the speed limit. This bill provides a pilot program to allow our state to start dipping our toe in these waters in a way that is A, voluntary, and B, applies only to the most egregious offenses. So here's what the bill does. If you are convicted of an offense that is an egregious driving offense and your license is suspended by the MVA, you have the option of having that suspension apply, or the MVA at its discretion can allow you to keep your driver's license if you install an ISA in your vehicle. And so this will allow us to gather data about the technology in a way that is voluntary and in a way that applies only to the worst offenders when it comes to our driving offenses. The ISA program would look exactly like our interlock program for alcohol. For indigent folks, they would be provided the same assistance that we provide for traditional interlocks. And the MVA, which is familiar with the interlock program, would administer the program in an analogous way for the ISA technology. We have some wonderful experts who can testify as to the safety and technology of this product. I will turn it over to them and ask for a favorable report on Senate Bill 366.
No, it's just stand up at the podium.
Committee, sir. My apologies.
Good afternoon, Mr. Chair, members of the committee. I haven't been in this committee for a while, Senator McCray. At any rate, for the record, Regina Ali, I'm the Public and Government Affairs Manager for AAA here in Maryland, Washington, D.C., and Northern Virginia, and I'm also a former Baltimore police officer. AAA is certainly here in support of House, excuse me, why do I have my hat? We're certainly here in support of this legislation today and commend Senator Waldstreicher for bringing this bill to the floor yet again this year. AAA recognizes that speeding is a serious problem on our roadways, and speed-related crashes are a leading cause of traffic fatalities, not just nationwide, but here in Maryland as well. With nearly 41,000 deaths from motor vehicle crashes in the U.S. in 2023, nearly a third of those killed, 11,775, were involved in speed-related crashes. According to the MDOT Highway Safety Office, there were 7,700 speed-related crashes in 2023, resulting in more than 32 injuries and 102 deaths. AAA supports requiring active intelligent speed assistance technology, or ISA, for combating repeat and, as Senator Waldstreicher said, egregious speeding offenders. While the use of this speed limiting technology to address this dangerous behavior is new, these devices have been used in public transit, municipal fleets, commercial vehicles, and some private vehicles around the globe and have demonstrated success in reducing speeds. Sadly, we know that speeding persists. A AAA Foundation for Traffic Safety Culture Index survey found that 61% of respondents perceived driving 10 miles per over posted speed limit on residential streets is very dangerous. Even though those respondents viewed speeding as dangerous, they admitted doing it anyway. In fact, 49% of drivers said they had exceeded the speed limit by 15 miles per hour or more on a highway. I know my time is up. I did want to say I'm remiss in not mentioning Sergeant Patrick Kep, Montgomery County police officer, who was supposed to be here today, but definitely will be in the House tomorrow. I had a work conflict today, but Sergeant Kep was struck in October of 2023 by a driver who was driving more than 100 miles per hour when he struck him intentionally, causing him to lose both of his legs. AAA was honored to support legislation last year, the Sergeant Patrick Kep Act, which passed and also addresses those drivers who drive in a reckless and negligent way. I thank you for your time, sir, and this committee, and respectfully urge a favorable report.
Thank you very much.
Thank you, sir.
Mr. Chairman and committee members, thank you so much for having us today. It's good to see you again. Many of you know the story of my wife, Sarah. She lost her life in Bethesda 3 years ago when—
I'm sorry, and just for the record, you're Mr. Daniel Langenkamp?
Yes, that's right. I'm Dan Langenkamp. Appreciate it. Thank you. So my wife was killed by a truck driver who veered his vehicle across a bike lane and struck her and crushed her. Since then, I've worked with safety advocates to advocate for, and legislators like Senator Waldstreicher, Senator Love, to pass safety legislation. Of all the legislation I have seen circulating this year, I think this bill has perhaps the most potential to save lives in our state, and that's why I'm working with Families for Safe Streets and others to try to pass it. Here is why the bill is so important. First, we know that speeding is a factor in nearly a third of all roadway deaths in America. So there are so many of those deaths, more than 3,000 a month in the United States. That's more than were killed on September 11th each month. Second, the drivers we're talking about are disproportionately responsible for deaths on our roads. According to the New York City Department of Transportation, drivers that receive more than 20 speeding tickets are more than 5 times more likely to be involved in a crash with a serious injury or a death. And drivers with more than 30 speeding tickets are responsible for, or are more than 50 times more likely than others to get involved in a crash with a death or a serious injury. Third, the law enforcement that we have for these type of drivers is simply not working. Statistics show that people who have received suspended licenses, 75% of them continue to drive anyway. And then fourth, the reason we should pass this is because Washington, D.C. and Virginia have these laws. And there's no reason why in Maryland, drivers and people on the roads should be less safe than the states and D.C. across the border. So to be clear, this bill only focuses on the most dangerous drivers, the people who rack up speeding tickets like trophies and who get back on the road again, poised to kill. Traffic violence is not inevitable. It is the result of our choices in enforcement, our choices in road design, and the choices about whether we're willing to use proven technologies like this one. Thanks very much.
Thank you very much, Senator Love.
Thank you, Mr. Chair. Just a point of personal privilege. I want to thank Dan for being here today and for all of your work over the years.
Very much. Thank you. Appreciate it. Good to see you again.
And just so that I'm clear, this technology, it hinders someone a driver from exceeding a certain speed?
A judge can require that that a person install this device in their car, and it keeps them from driving over the speed limit. That's right.
Okay, so.
And it uses GPS technology to determine what the speed limit is on that particular road.
All right, I see a smile. Yeah, can you, with speed limits changing and all that stuff throughout the state, how does that work?
Yeah, so GPS technology will tell you what the speed limit is on that particular road. And just like the way your Google Maps works, it knows what the speed limit is, and so your car has to go that speed limit. I think you can exceed the speed limit by 5 miles per hour so that you can merge with traffic and things like that. But there's a limit on, you're not able to go more than 5 miles an hour over the speed limit.
Got you.
Yeah.
Yes, ma'am.
Yeah, I was going to say, just to add to Dan's point, right? Yes, sir, I'm sorry, excuse me.
Money.
That's what I was going to tell him. Please come tomorrow, Senator Smith.
Advertisement, huh?
No, our partners will be hosting tomorrow a media availability as well as an availability for the legislators to see exactly how the technology works. The best way to say it is similar to an ignition interlock where you can't drive if you're above a certain limit, you've consumed alcohol. This will, and again, it's voluntary, it's for egregious speeders to basically, you're going to lose your license, but you can get this on your car. It literally will not let you go, but so far. And as Dan said, it's the technology, the mapping. It knows the speed limit in an area. I've driven it. It will change and slow you down even more depending on what the speed is. So we encourage you and your committee to come out tomorrow and see how it works.
Thank you.
Thank you.
Senator Folden and then Senator West.
I think he was before me, sir. All right, thank you, Mr. Chair. Whoever wants to answer it, is current interlock program devices, are those tracked by GPS?
Ignition interlock?
Mm-hmm.
I don't believe so. I don't believe so.
No, those don't. I think those
believe so.
work.
No.
Interlock is if you have alcohol in your
Do you mind coming to the?
Yeah, sorry. We're looking behind us because some of the manufacturers of our ignition interlock are here, and they're indicating that they are not tracked by GPS.
Okay, so I guess that kind of brings me to one of my things. I understand this would be voluntary, but that kind of does bring me to the idea that what if there's other, is there gonna, when someone has an ignition interlock put on, they blow into the device and it's not tracked, but it allows the vehicle to start, but it's not tracking where they're going. This one would be something where, because it's tracking speed limit data, it has to have GPS. So have we considered, or what are the unintended consequences for those that are not the intended driver, but like a spouse? It's still on, it's still there, and it still tracks their movement.
It is affixed to the vehicle, and so it would apply to someone who is not subject to it if that person were driving the vehicle. But that's no different than the ignition interlock. If I had an interlock on my vehicle ordered by a judge and my wife drove my car, she would have to blow into the ignition interlock.
Sure, I understand that. I'm just pointing out that the difference is one is tracked and one is not. One's simply access to a vehicle, the other is tracking a vehicle. So is that not, is that kind of an invasion of that person? If they're a registered owner, is that an invasion of their privacy And do we have, is there a criteria that they have to, I guess, agree to?
It's a fair question. So I'm not sure that the premise of your question is correct. It may be, it may not be. We'll check with the manufacturers. Obviously, it knows where you are in real time based on the GPS.
What may be, what may not be?
I'm sorry. The GPS obviously knows where you are when you are driving the vehicle.
Correct.
So it is tracking you in the sense that in the moment you are at this place at this time, it knows where you are. Whether it retains that data in a way that is accessible to anyone, I'm not sure that that's correct. In other words, if later someone wanted to know where you were at 1 p.m. on February 3rd, I'm not sure that it knows, it retains that data. So we'll get that information
I
from the
appreciate it. And
manufacturers.
then the date, you kind of answered the question. So it actually puts like a limit or a governor on according to suggested speed or the actual speed limits with some variance, I guess, for fluctuation. But it doesn't, at any point, does it would it shut down the vehicle if it senses like?
No, it's just a limiter.
Okay, all right, thank you.
Yep.
Senator West.
I think most of my questions have been answered. And my question basically are related to how does this system work? How does this technology work? Which really wasn't discussed in the original presentations, but has been addressed in some of the questions. Where is this demonstration going to take place tomorrow? If I had time, I'd like to go out and take a look at this system.
It's 10:30, 12:30. It will be from 10:30 to 12:30 tomorrow, right behind, on St. John Street, behind the House building.
Oh, that long stretch of straight right behind the House building?
Yes,
Between the
that's
House building
where-
and St. John's College?
Yes, yes, sir. And that's where it will start, but you'll be able to have that opportunity to take the vehicle out on the main road and to see
try to drive it fast.
and to
have
see
the
exactly
vehicle-
how it governs your speed. It literally will not let you go, but so fast.
Okay, I'm sure my questions about how this technology works can be answered by actually experiencing it in the car. Thank you.
It's a nice experience. We encourage you to come out. Thank you.
Senator Folden's questions piqued my interest as well. It was testified to earlier that this technology is being used in, you said Virginia and DC. And I'm curious, does the vendor, I mean, obviously it's collecting real-time data on you, but would that, I mean, from what you may be aware of those programs, does that information that is being collected real-time, do these states have anything within their statutes that limit the amount of time that these vendors can keep that information? Is it disposable after a certain amount of time? Because if its sole purpose is to ensure that you don't exceed the speed limit on that road at that time, after that, it's not needed. I think, is that what you're getting at?
That's exactly right. I think that's a really good question. I'm not sure that any data is retained at all. And we will find out from the manufacturers. And if that is, if the committee is empathetic with what we're trying to do here, but the data retention is an issue, we can put that in the bill if necessary. But we'll find out from the manufacturer if it is even retained at all.
To me, it's a fascinating solution to a real dangerous problem. So, I mean, outside of dealing with what the senator had mentioned, I think it's a great idea. Thank you.
Thank you, Mr. Chair.
There is no opposition and no other questions, so that ends this hearing on Senate Bill 366. Next, we have the Senator Love, Senate Bill 296.
Me, Senator Love. I feel so important. May I call up my panel, Mr. Chair? Thank you. We also have one witness who is online.
All right, thank you.
So I'd like her part of the sponsor panel. So
We'll
she
do
could be
so.
brought up.
We'll walk through everyone and then open it up for questions.
Thank you so much.
Thank you.
Thank you so much. Good afternoon, Chair and remaining members of JPR. I am Sarah Love, here to present SB 296, which addresses Maryland's housing of our children in adult facilities. So earlier today, we heard SB 323, the chair's bill to end Maryland's automatic charging of youth in a number of areas. SB 296 is a companion bill because right next to the question of how you charge the children is where you house them. Right now, because so many kids are being charged as adults, many of them are being held in adult facilities. So let's just hold on to that for a moment. Children as young as 14 who are charged with a crime in a facility with adults who have been convicted of crimes. As Chair Smith mentioned earlier, last fall, the Maryland Commission on Juvenile Justice Reform and Emerging Best Practices released a report, Maryland's JJDPA Compliance Crisis, Children in Adult Detention. And I want to read for you something that they found. Charging youth as adults and housing them in adult facilities, quote, fails to protect communities. Instead, it disproportionately impacts children of color, diverts resources away from critical services for children and families, places children in dangerous environments that more often result in subsequent violent or general criminal behavior, and undermines true accountability by depriving them of developmentally appropriate interventions that help them understand, take responsibility for, and grow from their actions. Federal law requires when a child is held in an adult facility that they must be separated by sight and sound from the adults, and that they may not be held in the adult facility for more than 6 hours without a court order. Prisons built for adults, by definition, are not equipped to house children. So in order to comply with the sight and sound requirement under federal law, which usually they can't, our facilities, especially our local facilities, have to put kids in isolation, or as we call it, to make it more palatable, restrictive housing. And so what that means is our kids are in cells by themselves or with another child for 22 to 3 hours a day. They do not get schooling, they do not get programming, they do not get mental health services, nothing. They do not get the services they need. This committee has heard time and time again, and multiple times today even, the harm of restrictive housing on our kids in general, and that harm is multiplied when we apply it to children. These kids are sometimes released from their cells for an hour or two to take a shower or make a phone call. So let's talk about when they are released, what happens. First thing, the facility, that area has to be shut down to try to comply with the sight and sound restriction. So everything has to cease while that child is being moved. Second, these kids are repeatedly traumatized. They can often see and hear the adults. So just imagine a child who's going to the phone to try to call their parent, and they are hearing these adults screaming at them. One child in a facility was threatened and coerced into giving other people his food. He didn't remove any of his clothes or shower for a week for fear of sexual violation. Another child at a different facility said there were days when she couldn't leave her cell at all. The experience gave her panic attacks. Quote, I was crying and I felt like I couldn't breathe. It was like bricks on my chest, end quote. And we're not talking about a few kids for a few days. Between January 1, 2018 and the end of September 2024, Maryland law enforcement booked teens in adult facilities nearly 4,800 times. And that number has only been increasing over time. Some of these are for less than a week, some are for over a year. So at the beginning, I mentioned that federal law requires the sight and sound separation and that kids can't be held in these adult facilities for more than 6 hours without a court order. And as you heard the chair mention earlier, not only are we out of compliance with federal law, we are so far out of compliance that federal data doesn't even include Maryland, because we would so skew the results. And because we are out of compliance, according to GOCAP, we stand to lose an estimated $2 million in federal funds to help these kids over the next 3 years. So SB 296 mirrors the language of and would bring us into compliance with federal law. Now, I want to say, I know that DJS submitted a letter of information. We've met with them several times. I thank them for their time and their interest in this. I strongly believe that we can address their concerns through some amendments. I also strongly believe we need this bill to pass along with the chair's bill. We have heard for years, and no disrespect meant at all to the current secretary, but we have heard for years from the department that they don't want to house kids with adults, and yet we're seeing that number go up time over time. So we need to pass this along with the chair's bill. We can extend the effective date to give the Department of Juvenile Services time to adjust to the new charging protocols, but I strongly hope that this committee will pass, sorry, I'm stumbling, will report a favorable report on SB 296. And with that, I would like to turn it over to Mr. Gordon Pack. Thank you.
Excuse me. Just thank you. I just want to say thank you for the opportunity. I've been before this committee several times in different roles, but today I'm here to share an experience I think may help show why this bill is important. As a 16-year-old, a week after my 16th birthday, I was put in the infamous Baltimore City jail. I was a little kid. I wasn't big and seasoned as other people who were there, the adults. So I was subject to a lot of hardships that I wish I could go back and change. The first night there, somebody robbed me of my watch. Within a week, I was on the tier out of receiving with a whole bunch of adults. They stole my commissary. They took the money I needed for the phones because he had the quarters to go in the cell phone, pay phones at the time. I've even almost got raped. I was in this situation for a very long time, and the hardship that I endured, the hardship that I witnessed, as things that I think people really need to understand, particularly for children in this situation. Some of the hardships that came wasn't physical assaults on the children. Some of it came from people saying, look, that's your co-defendant. He's snitching on you. Here's this knife. You go stab him because snitches can't be in the same place. So kids, they grow up together, they crimes together, they found them being at odds. Some people were used as doorknobs for the most part. They have them in these jobs where they keep coming out and people can continue to sexually assault them. I've seen people burn the cells up while they're in them because they have no other way of coping. I've witnessed guys and friends that were close to me to go on and develop drug habits, OD'd. I witnessed them catching murder charges in prison because that was the culture they came up with, and even joining gangs. So I don't want to belittle or berate this, but I really believe that we need to have a separation. Thank you. Please vote favorably for this bill.
Thank you so much. Can we go to, whoops, sorry, Ms. Jeanette Gonzalez?
Sure.
Next. Thank you.
Can you hear me, guys?
We can.
Okay. Good afternoon, Chair, Vice Chair, members of the committee. My name is Jeanette Graham. I'm the Executive Director at No Struggle, No Success Reentry Program, but I'm also a mother of a 15-year-old who was charged as an adult in the state of Maryland. While he was actually in the care of juvenile justice at Victor Cullen, they prosecuted him anyway. No case managers, no attorneys, no judges, no system officials consulted me as a mother prior to him being waived up and charged as an adult. He was actually placed in MCTC and also Frederick County Detention Center, where he was actually like a fishbowl, where he was surrounded around other adults, where they were showing their body parts, verbally abused him and traumatized him. They gave him drugs, and they also exposed him to sexual predators, and he feared for his life every day. He actually also have gotten stabbed. This is how Maryland This is how Maryland has allowed our children to be. My son, my entire life have changed. I became a reentry specialist simply to stop children going away to the adult prison system. There's way too many resources out here that will support children who find themselves in making bad decisions or becoming disconnected youth. Instead, this system currently puts children around broken, untreated, and traumatized adults with no rehabilitation. Individuals like Gordon Peck and others who spent years behind the wall now come home and still have these same issues because Maryland and the system are not speaking and taking care of our children. This also includes juvenile restoration, and my son's story continues to go on. He's still struggling, he still has issues, he's still serving time, when there should have been a situation where individuals should have, that's in the power, that has the money to do it, to make sure that there's public safety, human dignity for our children. I am still, to this day, although I am a thriving mother of 5, I have one son that's still in prison where he shouldn't have to be, especially around adults. Please vote favorable for this response. Thank you.
Thank you.
Thank you so much, Mr. Chairman. James Dold for the record. I just want to start by thanking Senator Love for bringing forth this legislation, and I'm testifying on behalf of Human Rights for Kids today. As I get started, I wanted to just start off by holding up a couple of pictures for committee members to take a look at. This is 16-year-old Kaylin Drake. She died by suicide about a year and a half ago in a Mississippi detention center in the South. The year before that, Joshua Beasley, 16-year-old down in Texas, who was held in an adult detention center, who also died. People here may be most familiar with the case of Cleve Browder, a young man who committed suicide after being held in solitary confinement for nearly 2 years at the age of 16 to 18 for a crime that ultimately it was found that he did not commit. Children held in adult correctional facilities are at a 36 times more likely to commit suicide than children held in juvenile detention facilities. Part of the reason for that is because they are placed, as Senator Love mentioned, in solitary confinement. We did a study here in Maryland where we surveyed people who are currently incarcerated for crimes that they committed as children. 80% of them indicated that they were placed in solitary confinement while under the age of 18 while being charged as adults. Those same children, when they're not held in solitary confinement, are often subject to severe abuse and neglect, often at the hands of older adult prisoners. In that same survey, we found that 75% of the children charged as adults here in Maryland experienced some type of abuse at the hands of older adult prisoners. 88% were physically abused, 57% were emotionally abused, and 15% were sexually abused or raped. It's really important that this legislation be passed this year as a complement to the chair's bill because we need to remove children from these horrific conditions in which they experience all sorts of violence. I'll also just note real quickly that the DOJ, in fact, issued a letter to GOCAP on January 6th of this year, alerting the state that it had lost $2 million because of the vast nature of these violations that are taking place. This legislation will correct that. Thank you.
Thank you to the chair, members of the committee for having me. My name is Sarah Sample. I'm here with the Maryland Association of Counties, and we are here to support Senate Bill 296. Thank you so much to the sponsor for bringing this. We really appreciate this legislation. We've already heard that we know that adult facilities are not for juveniles, and they do more harm than good. When it comes to the sight and sound separation, I've been to 5 detention centers this year. I went to 3 last year. I'm trying to get to the rest of them in the next couple of years. But I am seeing a big effort to try to comply with this. We're not just not trying. It is just the sight and sound issue is really impossible in these facilities that are built for adults. You can really only almost get there if you have them in a separate building. But even if they're in a separate building, they still oftentimes have to go to booking and or intake in the adult facility. So there's a massive compliance issue there, even when you're getting close to compliance. The other thing I would say is the isolation. You've already heard that. Sometimes that's the only option when it comes to trying to get that sight and sound separation close. And then the last thing I'll add is we are starting to lose our patience at Mako and across the counties with the argument that we're hearing from the state that they just don't have enough room for certain individuals. We have it with the mental health transfer backlog, hundreds of individuals who are there for hundreds of days, and we really need them to step in and help out here in some way, and we think that this is a possible way that they could really do that. We're dealing with the Maryland Supreme Court case right now that has to do with that issue. So I'll be here for questions. It's the extent of what I have to say. We also have Director Ross here, great for answering questions, but we very much support this bill, and we really would urge a favorable opinion. So thank you so much.
Good afternoon, Chair, Vice Chair, members of the committee. Thank you for the opportunity to testify. Thank you, Senator Love, for bringing this bill up. I'm Ryan Ross. I'm the past president of the Maryland Correctional Administrators Association and the director of the Charles County Detention Center. I'm here today to support with amendment Senate Bill 296. Ensuring that juveniles are not housed in adult facilities is vital to their safety, management, and specific rehabilitation needs. However, the bill's temporary 6-hour holding exemption isn't operationally feasible in Maryland's local detention centers in practice. It undermines the protection the bill is intended to provide. Adult intake and processing areas are not designed to provide sight and sound separation, and there's no realistic way to modify them to meet that requirement. As a result, even short-term holding will expose juveniles to the adult population. The 6-hour time frame is not attainable statewide. Many counties lack 24-hour access to a judicial official for initial appearances. And even where access exists, local facilities have no control over when a juvenile is seen. Transportation limitations, particularly during off hours, weekends, and holidays, further make compliance unrealistic. To ensure Senate Bill 296 works on the ground, we respectfully request removal of the temporary holding exception and an implementation plan from the Department of Juvenile Services by October 1st of 2027, addressing judicial access and intake capacity. The plan should also allow law enforcement to take juvenile arrestees to the closest juvenile facility for timely processing and judicial review. With these amendments and with the bill's 2028 effective date, Maryland can responsibly meet the intent of this legislation while protecting juveniles and ensuring realistic implementation. I respectfully urge committee to issue a favorable report on Senate Bill 296 with amendment. Thank you for your time and consideration. Again, I'm here for questions.
Excellent, thank you. Senator Love, we have another, I know you have some more members that are signed up in favor. I'm thinking let's hear from everyone first, and then we'll open it up for questions since everyone's here in favor. So if you have, is Ms. Wilt?
Yes, sure.
Yeah, come on up, and then Ms. Williams. Yeah, she's right there. Yeah. Go ahead, yes.
Okay, thank you. Thank you, Senator Love, for bringing this bill before the committee today. I'm Laura Wilt. I'm the senior attorney for Maryland Crime Victims Resource Center in Baltimore City, but formerly a career prosecutor. I believe that Senator Love will move mountains in juvenile justice reform if she passes this bill into law. At every hearing, every committee, what I've heard year after year, what you've heard year after year is the problem, the largest problem that needs to be solved in the juvenile justice system is that juveniles should not be in adult jails. Fix this problem by passing this bill. Don't create all the problems that will come with 323, and I say that respectfully. We need to do the right things for juveniles when they're first charged with violent crimes, or they are going to learn lessons that will cause more victims to be harmed. What's doing the right thing on behalf of victims? That's your voters want to be safe. They need a system that will take steps to protect them. The voters want a judge to make decisions based on where these juveniles will be housed and what happens. When current system, it allows that when a juvenile is arrested and a commissioner says, yes, they should be held, they go to an adult jail right now, and then the next business day, a judge will order under current law that you changed a couple years ago that they need to get moved to a juvenile system. It is that time period that this bill fixes and says, No, you are never to enter that adult jail, which means no federal violations. The current system that has a detailed transfer system benefits youth and community. Those evaluations that those kids take more serious than any other step in the juvenile process benefits our communities, benefits our youth. And if you ask me why waiver is not as good, I'd be happy to answer that before this group. Thank you. And do ask
I will
for
not
your...
be asking you that question, but, all right. Ms. Williams, you're up.
Thank you. Good afternoon, Chair, members of the committee. My name is Crystal Williams. I'm an attorney with the Maryland Public Defender's Office. I work in the Government Relations Division as well as the Mental Health Division. And I'm here to offer testimony in support of this bill on behalf of the Public Defender's Office, as we see this as an important and necessary step that Maryland, to ensure that Maryland is in compliance with federal law regarding the detention of children, but most importantly, to protect Maryland's children. As long as we uphold the practice of charging children as adults, compliance with federal law will be a perpetual issue. All children who are charged as adults in Maryland are actually immediately held in adult facilities, as you've heard through some of this prior testimony. And it's important to understand that despite this presumption that youth can be moved to a detention facility, that is dependent upon the jurisdiction in which they're charged. It changes throughout the entire state of Maryland. And children should not be subject to where they are charged in terms of how they are protected when they are housed in these facilities. We do know that there is a youth detention facility in Baltimore City. Even in Baltimore City, children are first processed through central booking. They all start an adult booking at the very onset of their charge. And so it's important that that point be made clear that regardless of the presumption, regardless of whether that motion is granted for them to move to an adult facility, they are all initially exposed to adults through the process of booking. After they are booked, then there is, again, it depends on where they are in the jurisdiction of the state of Maryland. Some counties will have them move to YDC. However, in most counties, even if the judge grants that motion for them to move, and I will just make a note because I know there was testimony earlier today, oftentimes the state's attorney does actually agree to have these children moved when they are charged as adults to be held in the DJS facility pending their transfer. But oftentimes these children are in local and county jails, as you've heard some of the testimony, and that is oftentimes in solitary confinement, which we know is detrimental and harmful to these children, and that should not be happening. So for those reasons, we ask for a favorable report. Thank you.
Cameron Askew, come on up. And then John Sexton, you'll be last.
All right, you guys hear me? All right, good afternoon, Chair Smith and members of the Judicial Proceedings Committee. My name is Cameron Askew, and I'm one of Governor Moore's appointees and the Legislative Director of the Maryland Youth Advisory Council. And I'm here today on the Council's behalf to share our support for Senate Bill 296. This is a valuable piece of legislation that proves a commitment to the fact that we can hold those in our justice system accountable while also ensuring their safety. Most importantly, this bill removes exemptions to juvenile separation, such as administrative capacity, further aligning us with the requirements of the federal standards that we've heard today, of which the state of Maryland commits some of the highest number of violations in the country. Young people are exposed to harmful conditions when placed in adult jails, as we've heard from the several witnesses already today, including the threat of sexual violence and bullying, and they're likely to commit further violence or criminal behavior as they're kept in these adult jails. Maryland's noncompliance with federal guidelines puts youth in danger, and it's my hope this legislation will prevent additional harm and begin to reconcile Maryland's positioning with regards to the juvenile justice system. And for these reasons, the council requests a favorable report from the committee.
Excellent. Thank you very much. All right. Well, last witness for the for this bill, Mr. Sexton.
Good day, Chairman. God bless all of you, commissioners. All right, so at 16, I committed a crime. I went to jail. I spent 37 years there as an adult, to the adult prisons. During that time, to a good appreciable amount of that time, I spent facilitating and developing youth programs to help young people come in there. And I can tell you a couple of things about that. One is almost to the number These kids can be saved, they can be rehabilitated, they can be refocused and develop into good citizens, good people, good men and women. Secondly, just coming from there not too long ago, I can tell you that this Maryland prison system and the adult system is no place for a juvenile, period. There is no chance that they will have to rehabilitate in that system right now. None, zero, zip. They will get corrupted and they will get chewed up and spit out. So if we don't pass this bill, a lot of those kids that are going to continue to go into there are going to get ruined. They're going to get corrupted, and they're going to perpetually reoffend. And that's all I got to say. I would say this, though. I would appreciate very much if you would consider amending the bill and putting more emphasis on what it is that you want. Articulate what you want. If you just leave to the juvenile system or the adult system to make it up on as they go, and you don't articulate what it is that you want and what your vision is, they're going to take it upon themselves, and I can promise you it's not going to be what you envision today. Thank you.
Appreciate that. Thank you very much. All right. Questions from the committee. We're going to go start off with Senator West.
Thank you, Mr. Chair. For the sponsor of the bill, let me start by saying I'm extremely sympathetic to what you're trying to accomplish here, and have been ever since I took a tour of a facility in Baltimore County and learned that there were juveniles in this adult facility. But it sounds, from what I've heard today, the problem is much bigger than I apprehended. I apprehended the problem being merely where do juveniles get housed if they're charged as an adult, but they haven't been convicted yet? Why isn't there room in the juvenile facility to hold the juveniles until they're convicted? Now it turns out that we have processing problems, because during the processing process, the juveniles are in the same, are exposed to adults. And beyond that, we have, I'm looking at the bill would require that juveniles who have been convicted as juveniles, but in adult court, they still be kept in a juvenile facility or separate from the adults. So it strikes me that we're going to need to spend a lot of money on new facilities in order to accomplish the goals of this bill, because we don't have the current facilities which would enable the goals of this bill to be achieved. Wouldn't you agree with that?
I wouldn't, Senator. Couple of things. First, we need to pass the chair's bill on auto charging.
Agreed.
That will take us a long way towards where we need to be to not be housing our youth in adult facilities.
Right.
Second, what we heard from the acting secretary is that if we do that, we will alleviate a lot of their space, because a lot of the kids that they're holding who have been charged as adults are there for a long period of time because they're waiting their transfer. So if they're started in the juvenile system, then they'll move through quicker, so they'll have more space. And then third, as to the kids who have been convicted, that was a discussion that I had with the acting secretary. And one of the things we're thinking about amending, because she said we don't have jurisdiction over those kids right now, so that would be a problem for them. So we're talking about maybe amending it to make sure that we're addressing the population that they can house, that they do have jurisdiction over right now.
Well, I'm thinking there would be a population, if this bill goes through, and Senator Smith's bill goes through as well, there's going to be a population of juveniles who get convicted in the adult court of adult crimes. And under this bill, they cannot be kept in the adult prisons, but neither would it be appropriate to have them in the juvenile facilities because of the crimes they've been convicted of. We're going to need new facilities, are we not, to accommodate this population of prisoners?
Do you want to take that, James?
Senator James Dole, for the record, we believe that these kids, many of these kids who are convicted as adults, actually could be safely housed at YDC in Baltimore City.
I'm sorry,
at YDC, the Youth Detention Center in Baltimore City, a lot of kids who get convicted as adults, as we understand currently, get placed at YDC. So there are facilities we believe that can safely house this population.
So you're saying statewide, youth who are convicted of adult crimes in adult court statewide could all be housed in, there's enough room in YDC?
We believe so, yes, sir.
Okay, well, that does help. I took a look at the bill, and it doesn't go in effect until 2028. Would you care to explain why there's this long delay?
Sure, and that is specifically to take into account the department's concern that if and when we pass the chair's bill, that they'll need some time to figure out what that's going to look like and to process the kids through. So that was intentional to give the department some time to absorb what they would be facing when the chair's bill passes.
And then I'm looking at the fiscal summary, which says, in relevant part, beginning as early as fiscal year 2029, general fund expenditures for the Department of Juvenile Services increase significantly to operate new facilities. There's no estimate of how much the increased cost would be, but it does say increase significantly, which suggests that I'm correct in my surmise that this is going to be very costly.
Do you remember? We had a conversation with the department about that. Do you recall, James? Because we did talk to them about the fiscal note, and her comment to me was they think they can do it with existing resources, but she was trying to explain things to DLS, and I don't want to misquote her, but she wasn't sure if things went through, but what she said to us was that they think they can do it with existing resources.
Okay, and then finally, what are we going to do about the problem of the charging? Apparently, the first 24 hours, apparently, we heard, I think we're going to hear from opponents or information from others that there simply is not the capacity at this stage in the various counties to, during the charging process, to keep the youth separate from the adults. So how are we going to solve that problem, that logistical problem?
Can you repeat the question on that one?
Sure. I read somewhere, or I heard from somewhere, that during the first 24 hours after a young person, a juvenile, has been arrested, while the processing is going on, that juvenile is exposed to adults during the process, and there's no way logistically currently to prevent that from happening, because we have 23 jurisdictions plus Baltimore City. And in many of these jurisdictions, there simply is no way to separate the youthful offender from the adults during the charging process.
Yes, I would say that is true. And when I was talking earlier during my testimony, I was saying that we do sometimes, very limited, I think it's maybe just one jurisdiction, there is a separate building that you can house them in, but there's no way to avoid the booking and intake process and having some interaction with incarcerated adults or pending incarcerated adults. I will say, from what I have seen, and Director Ross can maybe add more context to this, when I've gone into the booking and intake areas, what they are able to do is get the site separation down. It's mostly the sound issue, because they've been able to cover different windows and doors and things like that. It's not perfect, but the site piece is covered in some of the facilities.
As I say, I'm very sympathetic to the bill. I'm just concerned about the logistical elements. Thank you.
Thank you, Mr. Chair. Laura, so, because the chairman apparently wasn't willing to ask, I'll ask, why can't the waiver process, or why isn't it sufficient, I guess, is the question I want to ask.
Thank you for asking. And I didn't have enough time to address that in the first 2 minutes. The reason is because the transfer process is so beneficial. These crimes are serious. These kids need attention. When a youth is charged as an adult, okay, let's picture this bill passes. They're being held, if it's decided they need to be held, they're being held in a juvenile facility. The transfer process, if 323 doesn't pass, is still in full force and effect. That means it's all hands on deck, like you heard from Public Defender and from DJS. This is a lot of work from them. Honestly, I think that's some of what we're getting out of here. It's a lot of work for them. They got to get doctors to evaluate the youth, usually one, always one, if not two. There's 1 or 2 public defenders for each one of these kids through this transfer process. And my argument is that what I have seen in over 20 years of doing those juvenile cases is that those youth are invested in the process. They realize how critically important this is. The kids that walk into our juvenile court, if you don't believe it, go to your jurisdictions. The juvenile court system, one main reason that why waiver is not as an effective process is because the juvenile court system holds no teeth and the kids know it and their lawyers know it. And so when it comes to the burden of proof, I don't think the state's attorney's office is worried about the burden of proof. The transfer and the waiver hearings are the same. The problem is that the kid is in a system that has released them because of catch and release laws. They are in our books, they're laws, they're policies, they're both laws and policies. These kids will be released by the Department of Juvenile Services. You've all seen it in your communities. That is what will happen with these kids that are now being direct filed. They are going to be released by the Department of Juvenile Services. That's why they're telling Senator Love, well, we can't be ready to handle them until maybe 2028. Why? Because they're going to be releasing them. So if that's what you want, if that's what your voters want, if that's what that's what you have to decide when you go back to your communities. I say you push the Department of Juvenile Services to step up. They have booking procedures. They have booking. When you bring a kid into a juvenile detention center throughout the state, there's a place to process before they go into the building. So officers with this bill would bring them right to a juvenile facility. You do the booking there, and then you never have them enter an adult jail. Let's get the Department of Juvenile Services on board with that, because we cannot, when you're talking about why waivers and good, juvenile system has to, you have to try a case in 30 days. So if you try a case in 30 days, if you can't, that means your victim will not have any DNA evidence. You're not going to have any ballistic evidence. You're not going to have any experts whatsoever. Is that the system that you are saying, yes, I want first-degree assault, a shooting in Baltimore City, I want that charged in juvenile court? Because that's what 323 says. Thank you.
Shooting wouldn't be included in.
Thank you. Thank you for your answer. I know.
That offense would not be included, but anyway. Yeah.
Sorry for stealing your thunder.
I did want to say that the YDC is an adult prison facility. It's not a DJS facility. So yes, they take every person under the age of 18. If they're sentenced, that's where they go. It's just Baltimore City youth get to use that pretrial, and the rest of the state doesn't.
I would have Ms. Williams come up and just say all the reasons why Ms. Wilt was wrong, but we won't do that. That's a different bill hearing. For any other questions from the committee? Okay. All right. Thank you all very much. With that, that'll end the hearing for Senate Bill 296. We'll now move on to our final bill of the day, which is Senator Charles, which is Senate Bill 352. We're going to have Senator Charles' Chief of Staff provide his remarks, and then we'll have Mr. Wiggins provide support.
Awesome. Thank you. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and honorable members of the committee. For the record, I am Becca Rhodes, Chief of Staff for Senator Nick Charles, who proudly represents District 25, and I'm here to urge the committee to issue a favorable report on Senate Bill 352, the Old Line License Plate Program Act of 2026. This bill creates a specialty plate modeled after Maryland's 1911 design, featuring up to 5 white digits on a plain black background. This design is clean, distinctive, and rooted in Maryland history, and it is a look that many drivers find both classic and modern at the same time. We know there is real demand for this type of minimalist plate. In 2024, Minnesota introduced a very similar blackout design and sold more than 250,000 plates in its very first year. That success suggests Maryland is currently leaving potential interest and, more importantly, revenue on the table by not offering something comparable. This bill is about a new option for Marylanders, so I want to briefly address concerns that have been raised about its impact on existing specialty plates, particularly the Chesapeake Bay plate. I believe those concerns are misplaced because these plates serve very different purposes and different audiences. The Chesapeake Bay plate is mission-driven. People choose it to support environmental restoration and the work of the Chesapeake Bay Trust. That plate has been available for decades, and Marylanders who want to support that mission have had very much time to do so. The Old Line license plate, on the other hand, is primarily about aesthetics and customization. It appeals to drivers who care about design, heritage, and a distinctive look for their vehicle, many of whom would not otherwise purchase a specialty plate at all. In that sense, this bill is more likely to expand the overall specialty plate market than reduce participation in existing programs. Importantly, Senate Bill 352 credits most of the associated fees to the Transportation Trust Fund at a moment when Maryland is confronting a serious and growing structural budget challenge. Without new, reliable revenue streams, the state will be forced to delay critical work or transfer costs onto our residents that are already suffering from the current affordability crisis. The fiscal and policy note on this bill notes that with a conservative estimate, this bill could generate $1.4 million in the first 5 years. This bill offers exactly what we need right now, a practical, voluntary, and sustainable source of reoccurring revenue that strengthens the Transportation Trust Fund without raising taxes on working families. In our current fiscal climate, innovative revenue measures like this are not optional. They are essential for keeping Maryland's transportation system safe, competitive, and solvent for the future. For these reasons, I respectfully urge a favorable report on Senate Bill 352. And with me today, I have Grayson Wiggins, Senior Vice President of Government Affairs for the Maryland Chamber of Commerce, to speak more on the bill. So yeah, let's make some money, and thank you guys so much for your time.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. We are in support of the bill, and we thank Senator Charles for bringing it, and good presentation by Becca. So this is Minnesota's plate, and we got the idea from Minnesota because they enacted it, and in the first year generated more than $7 million. Indiana, and we have a news article to support that we can share with the committee. Indiana began selling theirs August 8th of this year, and according to a news report from November, it's already generated more than $2 million. And so this is a very popular item for drivers. To Becca's point, I think the fiscal note is positive. It may be underestimated based on what we're seeing in other states. And given the state's need for revenue right now, we think this is a unique and creative option that allows people to make a choice whether they want to purchase the plate instead of requiring them to do so. And we think it'll be a positive revenue for the state. We think it'll be positive for drivers as they connect with the history of Maryland as the Old Line state. And for these reasons, we are very supportive of the bill and would ask for a favorable report. Thank you.
Chair, is it Becca? Yes. Yes, Becca. Ms. Becca?
Yeah.
So for full disclosure, I am on the Maryland Agricultural Educational Foundation Board. And so we're very, we're proud of our ag tags and those type of things. They, in their testimony, they have, they would be supportive of an amendment that would articulate a sunset provision on this and limit the impact to no more than 2 years. And an amendment that would articulate the maximum number of plates to be sold. Can you take that back to the good senator and see if that's something he might be interested, or you may know right now if that's something you would be willing to?
Yeah, we can absolutely take that back. Like we said, we don't think it's in the same market, people that want to support the mission-driven plates versus people who want to have a customizable blackout plate. We do think those are separate markets. We're open to speaking about what can be done. We think there could be some more creative options so that they're not cannibalizing the same market, but I'll let Grayson talk to that as well.
So That's a great point. The way the bill is structured is it's set up as like an auction system, and this is really based on what Delaware does in the private market. So this is kind of more aligned with what Delaware has. You've probably seen them on the plates up there. And they allow people to retain possession of the plate, and they can then sell it on the private market at auction. And those fees, those plates have fetched north of $500,000 for one plate with a low number. And so what the bill does is it retains that ownership at the state level. So the state government will retain ownership of the plate, and they will auction it off to the public, who can then bid for the limited number of plates. So I think it's somewhat inherent already in the bill, but we're certainly happy to take a look at some language around that.
Thank you very much. Thank you, Mr. Chair.
Thank you, Mr. Chair. Well, that is what I wanted to talk about. I see here that the language about the auction. So your idea is an auction similar to Delaware, so people are going to bid higher for number 6 than they would bid for number 666?
Potentially, unless a number means something more personal to them. But it provides MDOT with the authority to set that up, and so that the market will pay what the market will pay. But it will be a net revenue positive because the payments are being made, and then MDOT retains the money under the program to cover their cost, and then the net revenue in addition to those costs goes into the Transportation Trust Fund under the bill.
Isn't this going to require MDOT to devote a lot of manpower to setting up these auctions and conducting these auctions and keeping all the logistics of the auctions straight?
Based on the fiscal note, it does not appear that way. It seems, I mean, you could do them online, I think, for relative, I think the number in the fiscal note is $27,000 or something like that for the auction.
Well, if one plate could bring as high as $500,000, then I guess you've covered the cost, haven't you? Yeah. Okay, thank you.
Thank you very much. I received an email from a constituent earlier this week about this legislation, and the email says there's a young lady who has been using the name Old Line Plate to identify her business, which is dedicated to the history of foods of Maryland. If you look at her social media under the name, you'll see how she does a great job teaching people about Maryland history through this lens. If the state uses the same name, it will be hard for people to find her, given how search engines work. And it says, I'm sure there are some great alternatives for the state that won't pose this problem, but it would be really tough for her to try and rebuild, rebrand, and it hurts. And who wants to hurt small businesses that is actually promoting the state and has been for years?
We're aware of that issue. So I am not much of a foodie myself, but I did look at the website. It looks great. We have no problem. I think the request was made to Senator Charles's office was to add the word license plate into the name of the program, which we have no problem doing. Yes.
Yeah, so we talked to Miss Kara May Harris, great website, you guys should check it out. It's about Maryland historical preservation. We also received a letter with favorable with amendments from Preservation Maryland about the same exact issue, and we have no intention of affecting Ms. May's business, Ms. May Harris' business. So we have submitted that amendment request. We sent it over to JPR. So it is adding that license so that it's the Old Line License Plate Program Act of 2026. So that should be resolved. We let Ms. Harris know and she's happy. So
thank you very much.
Yeah.
Seeing no further questions, thank you both very much. It's great.
Thank you.
Fantastic. With that, that'll end the hearing for Senate Bill 352 and the hearings for the day.